যেটা পাঠিয়ে দিই তারপর আমি কিছু করবো না।
মোবাইল হয়
আমি তো
তাহলে বুঝতেই তো কিছু চলে গেছে। But at the very outset, I said my unconditional apology. Yesterday, I have mentioned before your lordship that so far the appellate number two has not yet attained the majority. Actually, he has attained the majority few days ago. I have got the information.
That's why I'm asking.
Yes, ma'am. That's why I got the Aadhaar card of the appellate number.
So you have to file one application.
You can dispose of the matter, recording the majority. There is a disposed of matter, long pending issue. My other side is also appearing. All other parts are same. All other order is same. I have handed over the Aadhaar card of the appellate number.
এটাই অর্ডার কথা বলছি। Okay,
That's why
this
I
matter you are
yes,
asking.
ma'am. That's why yesterday I intimated to your lordship's court officer that
আগের অর্ডারটা ছিল না? দাও। Last paper. Within 4 weeks from the date of passing of this order.
Right.
In the name of both the claimants.
Both the claimants. That will be there. I'm grateful. Much of.
Number 7 and 8.
I appear for the 7.
এগুলোটা দিন আগেরটা দিন এইখানটা এই যে modified and as follows হয়েছে এই প্যারাগ্রাফটার পরে ঢুকবে appellant number 2 appellant number 2 has become major during the pendency of the instant appeal. Accordingly, the check in the name of appellant number 2 be disbursed in her name. Next para necessary correction in the cost title of the memo of the appeal be made accordingly by the department within a fortnight. তারপর যা আছে তাই ঠিক আছে yes item number 7 and 8
I appear for the petitioner. Well, I have used my exception to the report filed by the state. Another exception to original. Exception file for this, no? Yes. My lord, the stand of the state.
now where is the exception you have
Right.
filed on the earlier days exception on behalf of the petitioner
Lordship. In 7, Monayam Vishwas.
report in the form of affidavit Mr. Amrutullah Chatterjee is there
Yes.
with Supratim Dhar so
And
there are two writ
writ
petitions
petition. 7 is
you
of
are
mine.
one
8.
you are for 8 and you are for the 7
Seven.
very well
The facts are to be, my lord, brought to your lordship's notice first. Then I shall come to the exception, my lord, report and then exception.
so
Here,
today is why it is fixed on the two mentioned
we mentioned, my lord, for final hearing. That was the,
for final hearing
yes.
yes you can start it let them come you start it so what is the about the writ petition
Writ petition is about, my lord, there are 2 notification of just consecutive day for same Mauja. Page 13,
so you have challenged the FPS license in favor of respondent number 7
yes,
license has already been granted
granted,
so you have challenged the license in favor of respondent number 7
my lord.
what is the ground
Ground is, my godown is more suitable than that of the private respondent. Every criteria I fulfill and I was the most suitable candidate, but they refused my candidature only on the ground, since there are another vacancy, I could have applied for that vacancy. That is their ground.
no you whether your vacancy location your go down is not within the vacancy location
Absolutely, absolutely. They are showing, my lord, that is their tricks. First page 13, 19/10/2022 on vacancy declared. Your lordship kindly sees
yes
page 13. What is the vacancy area? Gada Beria. Mauja, Gada Beria. I am within that location. Now, next day, page 16. Another vacancy notification. On 21st. Earlier was on 19, this is 21st. Where is the vacancy notification? My lord, kindly sees Garaberia, nearby Garaberia Jame Masjid. Mouja, same.
Yes.
There are two vacancies. I applied for the first vacancy, Garaberia Mode. Mode, there is no description with regard to this mode. Where is that mode? Mode means, my lord, there are 3-4 roads connected in a
Junction
place
of 3-4
that
road.
is, yes, that is mode.
Yes.
Now, up from this mode, my distance is only 60 meters. And the private respondent's distance is, my lord, about 1.5 kilometer. That is my exception. My lord, they showed from my godown to the second notification's vacancy is nearer. But where is the specification that second vacancy is for within that locality?
Second vacancy is
Near Jame Masjid.
nearby Gandrabiari Masjid.
Jame Masjid. But Mouja is same. Under the same Mouja, everybody is eligible. I applied for the first vacancy. My distance is 60 meter away. Who have been selected is 1.5 kilometer away. Therefore, they sought to produce a Google map that is absolutely, my lord, concocted, and it has been manufactured. My lord, request your lordship to pass an order for an inquiry by DM or superior to ascertain the location. What is Garaberia mode, and whether my distance and the private respondent's distance is nearer. Their exception, kindly sees in their report. They have annexed on Google map.
Page.
Page is, it has not been paginated, but this Google map is on their report, your lordship, kindly sees.
Yes.
Yes. Here, your lordship, kindly sees Garaberia, middle portion, your lordship, got it? Garaberia. But they are saying vacancy point. How they could say vacancy point? Garaberia is a junction. That would be the vacancy point. They are showing the vacancy point, my lord, top vacancy point of Garaberia mode.
This is the vacancy location of first
Vacancy location that has not been ascertained. Only Garaberia mode.
Okay.
What is the Garaberia mode? Well, Garaberia mode is between Malutipur, and they shown the vacancy position in between the middle, the Garaberia junction. I will show the map, Mouja map. Where is the Garaberia? Therefore, inquiry is required with regard to the vacancy location. What is Garaberia mode? Where is that? And the distance between me and the private respondent.
Now, where is your in the map?
Yes.
Where is your proposed softcom go down?
My exception, your lordship, kindly sees.
No, in the map, I have seen the vacancy point of Garaberia
Yes.
near
And
Garaberia mode.
According to them,
Top of the map.
top is the, my lord,
Vacancy point.
position.
Location point.
Location point would be middle, but they shown top the vacancy position.
Okay. So
And
where
I
is the,
go down is, my lord,
where is
bottom.
the go down of the private respondent?
That has not been given by them very cleverly.
And they have not given your vacancy.
Yes,
your,
that is given bottom.
that is
But
also
go
not
down of Monaim Vishwas. This portion in their Google map.
okay.
From Gadabedia mode to my go down is only 70 meters away.
3.1 kilometer distance from the
Yes.
vacancy location, as they have stated here.
And this has been manipulated, my lord. My Google map, your lordship kindly sees.
How can it be manipulated?
My lord, your lordship kindly sees my Google map. Here, their map I have obtained from the Google. My lord, the distance between these is 1.4 kilometer. Total distance.
No, why you make the distance from Beep Telecom?
My lord,
You have made a distance from Beep Telecom.
no, prior to that, page 8. Page 8. This is their map. How they could say that in the top that is the center point. Gadaberia more is in the middle. There are 4 road crossing. From that, my go down is only 70 meters away.
No, you are not the fit person. What would be the central location?
That has to be ascertained.
So where is the notification regarding the central location?
Let them come. Well,
This is the only ground.
my candidature has been rejected only on that ground, because I could have applied for the second notification. I have not done so. But insofar the first notification, I am the suitable candidate. And your lordship kindly sees the sketch map. My lord, this is hand sketch, page 10.
10 of
My lord, my exception.
page 10 of your
This is hand sketch by a surveyor. My lord, there are 4 roads connected in Garaberia. My lord, Jame Masjid is on 50 meters away from that mode. Jame Masjid also another vacancy. And Sohel Alam, he is having his go down 1.7 kilometer. And my go down just my lord, top go down of Monaim Vishwas 70 meters away. That has to be ascertained. They will say, my lord, this is not our center point. It would be, my lord, 1 kilometer away. That cannot, my lord. They have to, my lord, describe the center point in their notification. They have not done so. Mouja is the only criteria. I am within that Mouja. My go down nearer. Vacancy notification, page 13, your lordship kindly sees. Where is the specification, center point?
My lord, my lord,
Let him finish first.
my lord, no, my lord, what I want to submit is, my lord, I am appearing only in respect of 8.
Tell
My lord,
Not
the other
7.
advocate in 7 is not present. So, my lord, I cannot deal with his arguments. I do not even have to.
ঠিক।
My lord,
ওইটা 7 এ আছে অমৃত।
I say, যেই হোক না, Doesn't কি রিটিভের আন্ডারে আসছে কাজে আসছে
So it is admitted
Hmm.
that your godown is located near Jama Masjid. That is the second notification.
Second notification. Near Jama Masjid, Jama Masjid and Mode is about 70 meters away. Their
Whatever may be,
notification is
I
absolutely
understand your contention that you have filed the application considering the first notification,
yes.
but they afterwards issued second notification.
Second notification. I did not apply for the second.
Mentioning the location which is nearer to your vacancy, to your proposed go down.
Well, that is not the law. A vacancy is declared. If I be eligible for that vacancy, I may apply.
So
Whether in Garabedia mode, I am eligible or not, that has to be considered. Whether that second notifications area is nearer to me or not, immaterial. Because within one moja, within 60 meters away, two notifications. That is absolutely illegal. They have not said for first vacancy, I am not eligible. And according to the
have you no whether you have received any notice regarding inspection?
in go down inspection, yes, yes.
Where is the notice? Page 21.
Yes, ma'am. First vacancy, 517. Inspected for first vacancy. Let's see, page 13, vacancy ID. (517). This is in respect of 517.
Yes. What is the name of the selected candidate?
Sohail Rana.
Sohail Alam Shah.
Yes, Sohail Alams. And his father is the brother of an existing dealer. That is another point.
His brother is an existing dealer. Brother of Sohail Alam Shah.
No, father of Sohail Alam Shah's brother.
Okay. Uncle.
Yes, uncle, existing.
Whether uncle within the relationship, definition of term of relationship.
Parents' brother relationship.
Parents, brother and sisters. When you applied for the vacancy?
Well, my application, page 20, it was on 28th January 2023.
28th January
Yes,
2023.
23. Because vacancies notification was published on 19th 10 2022, and I applied on 28th January 2023. Go down inspected on 8th February.
Okay.
And my another submission is this: their contention is my godown is nearer to Jame Masjid. That is also not correct. Well, at page 10 in the hand sketch, I find from Garabedia Mood to Jame Masjid is on 50 meters away, and from Garabedia to my godown is 70 meters away. Therefore, Garabedia is more nearer than that of the Jame Masjid. Page 10.
Yes. Any point?
No, these are the 2 points.
First is the location.
Location, ascertainment of the center point,
Location and center
Garabedia
point.
Mood, and the distance between from location to my godown and from location to the private respondent's godown. That is the prime criteria. He is 1.5 kilometer away. I am within 70 meters away.
Oh, this is your contention. They said your location, your
But
godown is
they said my location is nearer to Jame Masjid. But my location is nearer to Garaberia, or what is the distance that has not been ascertained. And
so Garabedia is the entire Moja.
Garabedia Moja, Garabedia Mood. Mood is a particular place where
No, mode is over a road. There may be a certain roads.
no,
More than one modes.
Garaberia Mood is connected by 4 roads from 4 sides. That is the mode. Well, they cannot say, well, the Dalos is Garaberia Mood. According to them, that is away, but not that. That has to be ascertained, because in the notification there is no clarification with regard to the
Yes.
place.
What is the vacancy location?
Yes. Now they are saying this is the center point. And second thing, they are silent about the private respondent. What is the distance of the private respondent? 1.5 kilometer. That has not been ascertained. That has not been uttered a single word.
It was there in the report. On 30 meters.
May I just assist your lordship to that?
Yes. These 130 meters is center point. Center point, according to them, is not the correct
According
position.
to them, center point is
It has been
top of the map.
yes.
And you are saying no, that is not the center
That
point.
cannot be.
You are saying that the mode, that is the four crossroads are the center point,
Center
is
point.
called the mode.
And this is the Moja map. That cannot lie. This is the Moja map. Kindly see, this is Garaberia mode. দেখেন একটু 4 roads are there. ওইটা দিয়ে দিন, একদম মার্ক করা আছে। Moja map, part of the government survey department.
There are different modes, different junctures over the road.
Mode is on. 4 roads connected.
Where is 4 roads connected? There are
The-
2 roads connected.
Circle portion.
No, circle portion, there are two connections. Top of there are certain connections. However, you have interpreted on your way. This is RS Moja map.
Yes.
What is the recent Moja map?
LR Moja map.
Yes. Place the recent Moja map.
Very well, I shall come back with the recent Moja map.
Okay, let me hear the state authority.
আমার মনে হচ্ছে fit নেই।
Ground is already on.
Just wait.
দাঁড়াও, দাঁড়াও,
One after
আমারটাকে
another,
শেষ হোক,
one after
আমারটাকে শেষ হোক।
First of all, my respectful submission is that I believe the read code is not sitting on the appellate jurisdiction.
তুমি কোনটাতে বলছো? Sorry, আমি interrupt করছি। My matter is
Seven.
7, are you 7?
We are in the
Therefore,
Where the 8?
when 7 we are not. Mr. Supratim is appearing. So we are in the. I tell you, Lord, what is the difference? These two. There are points already on read.
read টা
Could you please allow me, sir? Allow me. This is my term. Allow me.
না না, ও তো
Please
read
speak.
petitioner। ও read petitioner ও বলবে না?
Two vacancies have been
কথা বলছি।
identical. One is the Jame Moji, one is the Jame Moji. Gadeberium. Now, I am on the minute item number 8, whereby I have rejected the petitioner's credentials. Why?
Petitioner means kindly remember.
I understand.
This is
No,
8.
no. Yes, I am hearing.
So, should I proceed with the 8 or should I wait for this somebody come and make the submission? Then I will make the submission on
No, no. The issue is that
Yes.
you are on 8.
8.
Who is for 7?
So, I
Amritalal Chatterjee and
সুপ্রতিম ধর।
Supratim Dhar.
Supratim Dhar and Mr. Amritul.
No, why both the matters are taken up together?
I don't know,
Is there any-
because
I have no clue.
last occasion what happened? His matter came, well,
Okay,
possibly
okay, very well. I understand. There are 2 separate matters
Yes.
altogether. Very well.
dismissed on day.
I have heard your matter today, part heard. Okay, I'll fix that matter tomorrow. I've heard the matter from Mr. Amritalal Chatterjee or
Can it be
Mr.
day after
Supratim Dhar
tomorrow?
thereafter.
Tomorrow 10:30 I have got.
Not tomorrow.
Day after tomorrow.
Day after tomorrow, I have other matters. That is group 6 matters in the running.
বৃহস্পতি শুক্রবারে তো হয় না
Oh, next week then.
Next
Well,
Monday.
tomorrow I have got a
Okay, come on Monday then. Please take down. Item number 7. Let me pass the order. Argument on behalf of the petitioner heard in part. Let the matter fixed on Monday, 3rd of March for hearing on behalf of the state respondent. Under the same heading, let the matter appear under the heading of for further hearing of the state respondent under the same heading. Give me item number 8.
I am doing my lord only on the ground of relative. I adopted the my lord submission of my lord only on the ground of relative.
So you have challenged the notification.
Only on the
Notification of what? Jama Masjid
no,
or mode?
no. I am on the ground of relatives that the private respondent number 10 was
No. I want to know whether you are a candidate,
yes.
you are an applicant,
On a very mode.
mode,
Yes.
wherein the present petitioner of item number 7 was applied for.
Yes.
Yes.
Okay, you have also applied.
Yes.
Follow the same.
Very well. Then what happened?
Well, I am challenging this only on the ground of my lord relatives. The private respondent number 10 was selected. The private respondent number 11 is the brother. Thereafter was my lord
Private respondent number 10
was selected.
was selected. And your contention is that?
They are the relatives. Private respondent number 10 and 11 are the relatives.
What relatives?
Parents, father,
Parents' brother. Sohail Alam, son of Abdul Razzaq.
son of Abdul Razzaq, and Alamgir Shah, son of Alauddin.
So you are saying Alamgir and Abdul Razzaq are the brothers, full brothers. And what is your status? Who are you?
Unsuccessful candidate. I am for the my lord unsuccessful candidate. I am on the ground of my lord only. I have annexed the my lord voter card, list my lord. In reply,
So you have also used exceptions.
exception, page 11. Serial number 803. Alamgir Shah, private respondent number 11, father of Alauddin Shah, and my lord,
You are reading page
page 11.
11?
Section,
Yes.
serial number 803. Voter list.
Yes.
Alamgir Shah, son of Alauddin Shah. Alauddin Shah and the father of the private respondent number 10, Abdul Razzaq. That is page 12. Serial number 780. Last. Abdul Razzaq. The brothers.
Where is Abdul Razzaq?
Kindly see page 12, last line corner.
That is Muhammad Sohail Alam Shah.
Yes, son of Abdul Razzaq.
Where is Abdul Razzaq in the list?
Yes, kindly page 11, first line, first 781, Abdul Razzaq sir, Imarat sir, son of.
Yes, different persons.
Yes, no. But Imarat sir, son of. Imarat sir has three sons, Abdul Razzaq, Alauddin, and Abdul Bari. Kindly see 781, 795, and my lord 801. Abdul Bari Shah, son of Imarat Shah, 795, Alauddin Shah, son of Imarat Shah, and my lord 781, Abdul Razzaq Shah, Imarat Shah. Imarat Shah has three.
Abdul Razzaq Shah. Where is Abdul Razzaq Shah? Item number?
781, page 11.
Abdul Razzaq.
Shah, son of Imarat Shah, first.
Yes.
Imarat Shah has three sons.
And my lord, Abdul Razzaq Shah son, MD Shoail Alam, private respondent number 10, and Alauddin Shah son, my lord, Alamgir, private respondent number. The full brother.
Who are the full brothers? Alauddin Shah,
Alauddin Shah and the Abdul Razzaq Shah.
Alamgir Shah is the Alauddin Shah's son.
Alamgir Shah, yes, Alauddin Shah. Imarat Shah has three sons, Abdul Razzaq, Alauddin, and Abdul Bari. 781, 795, and 800. Imarat Shah has three sons, Abdul Razzaq, Alauddin, and Abdul Bari.
Abdul Bari Shah.
Abdul Razzaq son, MD Shoail, MD Shoail, private respondent number 10 was selected.
Yes.
And Alauddin son of Alamgir Shah, private respondent number 11.
What is the relation?
Brothers, and first of all, my lord, there was selected in the name of father of Alamgir Shah, private 11, private respondent number 11, my lord. Father of Alauddin Shah. Thereafter, the license was transferred to the Alamgir Shah. At that time.
Yes.
My contention only. The relatives are not the minor. Kindly see the minor page 9. Page 9. Para 13.1. My exception. A person holding a license of FPS dealership or distributor or wholesaler in his name or a person whose relatives already has FPS dealership, the following persons entities shall not be eligible.
Page
Page my lord 9
of your
my exception.
page 9.
Page 9 my lord. Para 13.
Yes.
Following persons stroke entities shall not be eligible to apply for a license of APS dealer.
Yes.
1. A person holding a license of APS dealer or distributor or wholesale in his name or a person whose relative already has a APS dealer or distributor or wholesale. Only my XA relatives definition.
What is the definition?
XA.
Yes.
I am from the parents' father.
Which parents' brother?
Parents' father, my lord, with the Alauddin in the name of at that time.
Respondent number 7.
Respondent number 10.
10. What is the name? Sohail.
10 was selected.
Sohail.
Yes, 12.
Sohail's father is Abdul. Abdur.
Yes.
So Abdur has three brothers, full brothers.
Yes, Alauddin.
Alauddin.
Yes, in the name of Alauddin. The license was in the name of Alauddin.
Now I was say Alamgir.
Well, thereafter the license was transferred to avoid these rules, my lord.
That is not the way you are arguing. I want to know whether they are the license is running in the name of Alamgir.
Alamgir.
So Alamgir is not in the
time,
parents'
license was the
brother's
Alauddin,
parent.
my lord. At the time of my lord, the selection process was there, my lord. At the time of the license was Alauddin. Thereafter, to avoid the my lord process, license was transferred.
Admittedly, parents, brother or sister,
Yes.
that is the Sohil parents, brother or sister is not running the license now.
At that time of application, the license was in the name of Alauddin.
Where is the document?
The document is in the department. my lord. Kindly, my lord, put
So
in
you
the-
have to raise a allegation, so you have to justify that. Some document has to be there. At least some snaps that the license was running by the shop is there. You can take a snap.
Can you produce the report, my lord, that at that time
No,
the
the-
license was not
You,
there in the
you
name
first
of Alauddin?
substantiate, thereafter I will ask for the report.
Praying for my lord, kindly grant
No,
me
you have
supplementary, my lord.
no, you have stated in your read petition
Yes, yes, I have
that
stated, my lord.
item number, sorry, the respondent number 11 is running a license.
Yes, my lord. At that time, my lord, at the time of application, the license was in the name of Alauddin.
Now you are saying you have made a party Alamgir. Who is running the license now? That is
Alamgir, my lord. Currently, the
11.
Alamgir. But at that time of application, the
Oh.
license was in the name of Alauddin,
very
the father.
hard. Yes.
The negative equity cannot provide any locus to the petitioners. The petitioner is an unsuccessful candidate in the selection process. If your lordship kindly go through my report once, I just indicated why.
Report.
Now first, kindly come to me at page 7.
Yes.
I just indicate two very significant things, then I will come back to my pleadings. Lordship, kindly see the notification dated this 19/10/2020. Kindly see the vacancy ID 517.
517.
Correct. Now kindly see the details of the location of the vacancy. This is
Garaberia.
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 Now kindly come to page 10.
Yes.
Kindly see the notification dated 21st November 2022. Now 514. The earlier one of 517.
Yes.
This is 514.
Yes.
Now kindly see the village hamlet Pada. Garaberia, nearby Garaberia, Jame Masjid.
Jame Masjid.
Now these two are completely different vacancy. Now kindly come to Miller, page paragraph 5 onwards. I have just Miller described why the confusion has been created in paragraph 4 onwards. That there is two vacancy notification has been announced. Identically similar in nature appears to be, but there is different. One is Garaberia and is a Garaberia Masjid. What the person concerned, the unsuccessful person did, he has wrongly applied in one of the vacancies. Now, accordingly, Miller,
That is
He-
petitioner applicant in 8.
8.
Yes.
Now, I have just he has submitted in the vacancy number 514. His vacancy, he ought to have been submitted the vacancy on 517.
But he had applied on
514.
That means Jama Garaberia.
No, I sorry. 517
517.
is to be. Kindly see, in this case, applicant had applied for the vacancy near Garaberia against the vacancy ID 517. He has applied for the 517. But the applicant's godown situated near the Garaberia Jame Masjid. Therefore, the applicant was wrongly submitted. It should be originally been submitted against the vacancy number 514 respectively.
Yes.
So millet, this naturally millet, the go down is coming in a different millet Moja and a different vacancy as well. The entire latitude and longitude is different. And this is one of the part. Second part is that I have described in my paragraph 6 that the applicant go down is situated far away from the central location of the vacancy area. This is quite clear. The said go down is situated out of the vacancy area from the latitude and the longitude captured through the inspection app. In the said go down is situated another vacancy area, because he has applied in the 517 and ought to have been 514 respectively. So naturally Miller, this part is being prohibited. So what is the stand today? What is the stand today? He is an unsuccessful candidate. How he has become the unsuccessful candidate? I have described it in paragraph 8. Millet, the recommended candidate
Yes.
obtained the marks 86. Have you lordship got it, Millet?
Yes.
Now, whereby the Julius Jaman has obtained 69 marks only. The difference is huge. Millet, I have also given the same, and so far the prohibited relationships are concerned, which is lordship has just now observed, that is not clearly covered under the prohibited relationship as per the statute. And even the part 3 of the our vacancy notification, he is not coming under. So thereby, question is that if an unsuccessful candidate can come up and challenge the same on a frivolous ground, rather he can stop the public distributory system at his own whims and will. Answer is no. So Millet, the pith and substance of the matter in a very fine, I would say that the person concerned is an unsuccessful candidate number 1. He has applied in a wrong vacancies. So thereby he cannot be considered, he cannot be come within the considerable zone even. So if he has not applied within the Millet stipulated vacancy, he cannot be even considered as even an applicant. Not even an unsuccessful candidate, he cannot be a new applicant to that extent. Now, the person concerned to whom we have awarded the Miller the same. So, my lord knows fair play in the giant, same manner. The 8 stages of the Miller, the scrutiny has been going on. The person concerned who is holding the license is not coming within the prohibiting zone. So naturally we are given, there is no bar. আর কিছু বলার আছে? 7টা শুধু তোদের বলার আছে। না 7টা জোসেফ বলেছেন আলাদা বলে। ঠিক আছে আমাদেরও ঠিক আছে। No, Millet, I do not think much anything, because if your lordship kindly see the Millet, the judgments of the Millet same, I would like to cite 2 judgments only.
Yes.
Even time kindly see.
Let him finish. Let him finish.
It is 79 3 Supreme Court cases 489 Ramanna Dayaram Sethi versus International Airport Authority of India. Now,
Yes.
lordship knows the judgment. I need not to bother your lordship once again. This is one. Second is of lordship knows this judgment as well. 2008 4 SCC 619 Shadananda Holoi. When the Miller, the fact-finding committee come to a conclusion, read court cannot alter and otherwise. These 2 judgments are good.
Once, my lord, kindly see page 42 of my writ petition. Kindly see once. Town was inspected. The vacancy ID 517, page 42. It is the letter of the area inspector. Page 40.
What is
Page 42.
517 is the
Yes.
Ganaberia,
Yes.
Moja Ganaberia.
Yes. I am covered by the 517.
Yes, 517 is Ganaberia. This is the argument of the state
But kindly
that you are fall under 514, not 517.
no, I am on the 517.
Yes, they have argued that your go down is within 514, not 517.
No, my lord. My go down is another my lord point. I am only on the point of relatives.
Okay. Mr. Chatterjee, I shall hear the item number 7 Monday. Next Monday. Matter made part heard. Okay. Please take down. I am passing the judgment in respect of item number 8. Petitioner applied for FPS license in pursuance to the vacancy notification issued by Subdivisional Controller Food and Supply, Dome Call, Void memo number 1061, dated 19th of October 2022, through vacancy ID 2022 0022 3517 for vacancy location Ganraberia within Moja and jail number Ganraberia -044. Full stop. It is the contents. It is the only contention of the writ petitioner that private respondent number 10 was awarded license by the respondent authority. One of the relative of private respondent number sorry, কি বললাম private respondent number কত বললাম 10 was awarded license of the FPS. One of his relative, that is private respondent number 11, is running a FPS license. It is the contention of the learned counsel for the petitioner that one Imarat Shah had 3 sons, namely Abdul Razzaq Shah, Alauddin Shah, and Abdul Bari Shah. Full stop. Abdul private respondent number 10 is the son of Abdul Razzaq Shah. Full stop. Alauddin Shah was running the FPS business, FPS license. However, during the license during the vacancy notification, but afterwards such license was transferred in the name of Alamgir Shah, within bracket private respondent number 11, who is the son of Alauddin Shah. he submits that at the time of vacancy notification, Alauddin Shah was running the business. Thus, the private response number 10 cannot run the business because one of his relative is running the business. Full stop. Learned counsel appearing on behalf of the state authority submits that the present petitioner is an unsuccessful candidate. The concerned SCFS has concerned district level fair price shop selection committee recommended private response number 10, who scored 86 marks in total, wherein the petitioner has only obtained 69 marks. Mr. Sengupta, learned counsel appearing on behalf of the state respondent, further submits that being an unsuccessful candidate, the petitioner has no right to challenge the decision of the competent authority. He placed his reliance upon the decision of Honorable Supreme Court in Ramanand Dayanand Sethi বলে দিচ্ছি ওটা পরে হয়েছে। Having heard the learned counsel for the parties and after perusing the report filed on behalf of the state as well as the exception by the petitioner, it appears to me that the respondent number, private respondent number 11, is a son of one Alauddin Shah. There is no materials to show that Alauddin Shah was running a business. Moreover, it is the admitted fact by the petitioner that one Alamgir is running a business. Full stop. Alamgir happens to be Alamgir within bracket respondent number 11 happens to be the happens to be in relation with the private respondent number 10 to be parents, brother's son. Okay. According to the provisions of clause 2 within bracket X A, the relatives defined as follows: XA of WPDS MNC order 2013. The relatives defined as follows. এটা করে দেবে, ঠিক আছে? এখান থেকে একটু from the above definitions of the relative, it appears that parents, brother or sister are coming in under the definition of relative. Full stop. The present respondent number 10 and respondent number 11 are not coming under the definition of relative. Thus, in my view, the allegation raised by the present petitioner in this writ petition is not justifiably considered. Accordingly, the instant writ petition being meritless, dismissed and disposed of. Next,
Obliged, Lordship.
This is the review application.
Yes, sir. With the leave of my learned senior Milord, Mr. Achut Bose, I am addressing you for your lordship.
I'm for the respondent, Milord.
Milord, on
The ability point with regard to this, Milord, whether any review application is maintainable for interest part, Milord.
this is not the question of interest part, Milord. This is a
Milord,
substantial
review is very simple, Milord. Review can only be done if any mistake is there on the part of the apparent on the part of the record.
that is a
Save and
different
except,
issue,
Milord,
Milord.
review cannot lie, Milord.
That's why I shall hear out the review. If you raise any point of maintainability, I have to hear out the review.
Yes. Milord, kindly come to the Order 47 Rule 1.
Now, where is the review application?
This is the memorandum of review has been filed, Milord. This is
देखो review টা কই?
memorandum of review.
দিচ্ছে না কেন? Oh, page.
They are going into the facts of the case, Milord.
Let me peruse the order first.
Yes, Milord. That is the order dated 20th August 2024. The petitioner approached the railway tribunal for getting compensation on the ground of untoward incidents wherein her husband was died in an accident.
Yes.
The railway, your lordship got it, Milord?
Yes.
The railway tribunal awarded the compensation amount to rupees 3 lakhs together with interest at the rate of 6% per annum from the date of award in favor of the petitioner. Being aggrieved by the said direction, the petitioner approached to the appellate court wherein the appellate court has directed that the interest should be calculated from the date of filing of the application. The division bench of this court has also awarded further interest at the rate of 10% to be calculated from the date of application to till the deposit towards the additional interest. The railway tribunal has not awarded the interest as directed by the division bench. Accordingly, petitioner approached before the court in the CO number 3858 of 2018. A coordinate bench of this honorable court has directed the tribunal to pay the compensation along with additional interest at the rate of 10% per annum as directed by the division bench. Against such order, the railway authority has approached to this to the Honorable Supreme Court in special petition number 927 of 2020. The Honorable Supreme Court has refused to entertain the SLP. Thereafter, Milord, we have taken the ground of compensatory cost, Milord. Why, Milord? I shall cite your lordship the several Supreme Court decisions, Milord. Before that, Milord, I am coming the order again. By virtue of the direction of this court, the Honorable Single Bench, the tribunal has passed an order on 19th July 2019 regarding the calculation of compensation or interest. According to the petitioner, the calculation made by the tribunal is erroneous, hence the instant CO has been preferred. During argument, the learned advocate appearing on behalf of the respondent submits and admitted the calculation made by the learned tribunal is erroneous. He has specifically submitted that the true and proper true purpose and purport of the direction of the learned division bench if properly calculated an amount of more than rupees 6,45,000 is due and payable today is unpaid to the unpaid on the account of penal interest. Learned advocate of the petitioner assessed to the submission of the learned counsel of the respondent correct in respect of the calculation of interest. Learned advocate for the petitioner submits that the facts suggested the present petition is roaming before the court in several forums to get the proper compensation. He submits that his husband was died in an accident on 20th August 1998. Since then, she is running pillar to post to get the proper compensation. The learned counsel further submits that this is the incidence of protracting litigation by the respondent only to deny the proper compensation to the petitioner. He further submits
that the defense as well as submissions of the railway authority in several proceedings are false and vexatious. So the petitioner is entitled compensatory cost. My lord, on this compensatory cost, my lord, which I have cited 2014 volume 8 SCC page 417, that is on protracting litigation. But when my lord, I am submitting before your lordship about the compensatory cost, my lord, I should have cited the 2005 volume 6 SCC page 344, my lord, that is the Salem Advocates Bar Association Tamil Nadu versus Union of India. My lord, it has been dealt with the different with the amendment made in the year of 2002, and my lord, the cost is required to be, my lord, considered as afresh, my lord.
So why this review application?
My lord, the compensatory cost is required to be elucidated, my lord. My lord,
No, you read page 19.
page 19 of the order.
Yes. Page 19. Page inner page 8. Inner page 8. Second paragraph. That is the first paragraph.
Yes, my lord,
The
for
entire fact.
that as because 10% is sufficient. But my lord, the observation of the Honorable Apex Court is a bit different, my lord. I am praying your lordship certain relaxation to produce these judgments only, my lord. Nothing else, my lord. And after all, my lord, it's all upon your lordship whether, my lord, my review application
no.
will be allowed or not.
Whether in review you can challenge the specific order of this court.
No,
You
my
have to go
lord,
to the appeal.
I'm not
No,
challenging
you
this.
just read the
I'm
last line. The interest is running day by day,
Yes.
and this is why I find nothing to entertain the present petitioner to pass an order for compensatory cost.
Yes,
This is
my
the
lord.
positive finding of this court.
My lord, this is
my lord,
this is the penal interest because of their laches made by the railway authorities. That is the reason, my lord, the petitioner has been granted to that by this honorable court.
No, I have granted you already the interest.
My
is
lord,
running.
that is, my lord, the continuation of the earlier division bench.
Whether this fact, whether this observation of this court can be challenged or
My lord,
in a
I'm not
review,
challenging, my lord. It can be reviewed, my lord.
how can it be reviewed?
Yes, my lord. I'm
Order
just
47 rule 1.
yes, my lord. Yes, I'm coming to that, my lord.
Read order 47 rule 1. Is there any scope to sit appeal
Yes.
in my own order?
No, my lord, I'm not on that, my lord. Order 47. Order 47 বুঝতে পারছি না। Yes. Application for review of the judgment. Any person considering himself aggrieved by a decree or order from which an appeal is allowed, but from which no appeal has been preferred. So I have not, my lord, it is not possible for my client to afford one SLP, my lord. That is the whole problem, my lord. That is the, my lord, if your lordship consider and rehear the case.
No,
to
whether
some
there is
extent.
any scope for
Yes, my
consideration.
lord, I am coming to that, my lord. By a
See the
decree
relevant
or order.
judgments recently. Appeal in disguise cannot be allowed in review application.
My lord, this is, my lord, these points, even, my lord, this is the, my lord, AIR 2005 volume 2005 Supreme Court, my lord, 592, my lord, this is between the, that is the
You read
board
the
of,
judgments of Mayabati and thereafter
No, no, no.
all judgments are
board of
everything is
control of
going on
cricket,
that way.
cricket of India versus Netaji Cricket Club, my lord, this is sufficient reason in rule 1 is wide enough. My lord, if the compensative, my lord has said, your lordship have said that the 10% penal interest is quite sufficient enough because it is taking protection till the date of payment. So compensatory cost is not required. My consideration, my lord, my submission before your lordship and the prayer before your lordship is compensatory cost is not, my lord, the only penal interest. When a successful party appears before your lordship and being a pauper, actually, my lord, he is a very poor fellow. Then, my lord, it is required to be compensated how much he has spent in the Supreme Court, through the, that is the observation made by the Bar Salem Bar Association versus Union of India. So, my lord, I am referring the paragraph 36 and 37 of this 8th judgment.
This is the ground. This is the only ground.
This is the only ground, my
Very
lord.
well. Yes. Give me the citations.
Yes. My lord, it starts from paragraph 36. My lord, got it, my lord? Paragraph 36. Section 35 of the code deals with the award of cost, and section 35A with the award of compensatory cost in respect of false and vexatious claim or defenses. Section 95 deals with the grant of compensation for obtaining arrest, attachment, or injunction on sufficient ground. These three sections deal with the three different aspects of the award of cost and compensation. Under section 95, cost can be awarded up to rupees 50,000, and under section 35A, the cost awardable are up to rupees 3,000. Section 35B provides the award of cost for causing delay where a party fails to take steps which was required by or under the code, or to take or obtain an adjournment for taking steps for producing evidence or any other ground. In the circumstances mentioned in section 35B, an order may be made requiring the defaulting party to pay to the other party such cost as would, in opinion of the court, be reasonable, sufficient to reimburse the other party in respect of the expenses incurred by him in attending the court on the date, and payment of such cost on the date next following the date such order shall be condition precedent to the further prosecution of the suit or defense. Section 35 postulates the cost shall follow the event, and if not, reasons thereof shall be stated. The award of cost of the suit is in discretion of the court. In section 35 and 35B, there is no upper limit of amount of cost awardable. Judicial notice can be taken of the fact that many unscrupulous parties take the advantage of the fact that either the costs are not awarded or nominal costs are awarded against the unsuccessful party. Unfortunately, it has become a practice to direct the parties to bear their own cost. In a large number of cases, such an order is passed despite section 35(2) of the code. Such a practice also encourages the filing of frivolous suits. It also leads to the taking of frivolous defenses. Further, whether the costs are awarded ordinarily, same are not realistic and are nominal. When section 35(2) provides for the cost to follow the event, it is implicit the costs have to be those which are reasonable, incurred by a successful party, except in those cases where the court in its discretion may direct otherwise by recording the reason therefore. The cost have to be actual reasonable cost, including the cost of the time spent by the successful party, the transportation and lodging, if any, or any other incidental costs besides the payment of the court fees, lawyer fees, typing, and other costs in relation to the litigation. It is for the High Court to examine this aspect whenever take necessary and make requisites, rules, regulation, or practice direction as to provide appropriate guidelines for the subordinate courts to follow. Then thereafter, my lord, there is a marks, my lord, there is a sign, and my lord, there is a the importance of awarding true cost is discouraging the frivolous, vexatious litigation cannot be emphasized enough. The Supreme Court has in recent cases awarded cost or exemplary cost against the parties had been prosecuted various proceedings only with a view to prolong them or to vex the other party. So these are the cases, my lord, where the exemplary cost was. My lord, I have two more judgment, my lord. Thereafter, my lord, I shall conclude. My lord.
What? For what?
On the same ground, my lord.
No, I want only one judgment, that this court can entertain your review application.
Yes.
Your review application on the point why when this court has categorically denied your compensatory cost,
So that
whether there is a scope of review. I understand your all contentions.
Yes, Milord, kindly allow me to cite one only
No,
judgment,
No,
Milord.
no, nothing.
Yes,
You just satisfy me first that I can entertain the review application
this
on
is-
that point.
this is the this is
Only clerical, arithmetical mistake.
no,
can
Milord.
be
This is
occurred.
apparent
this is the clerical arithmetical mistakes are not the part of review, Milord.
I have
This is a
passed a
substantial when
specific observation that you are not awarded a compensatory cost. If you are aggrieved against the order, you have to
prefer an appeal,
appeal.
my lord.
Milord, kindly have a
I
look.
cannot sit appeal over my order.
Milord, I am not on this, Milord.
Then
This is
what
the
you are
this is
there?
this is the question of law, Milord, which has been
Question of law, this court has not considered.
Milord, that has not
Admittedly,
been
at your view.
that has
So
not
you
been
go to
brought
appeal.
before your lordship. This is
No,
my
that is not
ability.
the-
I have not
no,
brought
no,
before your lordship.
No. Facts are already there.
Milord,
Not
Milord,
the law.
kindly
Order 47, rule 1 says a fact. You read the 2,
yes.
sub rule 2. Only new fact. What is the new fact here? Nothing. Conscious order is there. You cannot challenge the order in review. You have to prefer an appeal.
Milord,
You cite me any authority that this finding I can alter or change in review jurisdiction.
then Milord, kindly give me 2 more days, Milord. I shall come back.
I have fixed today for hearing. Okay, you conclude the argument. If you I shall not pass order within that 2 days, you can submit.
Yes, Milord. Then Milord, allow me to cite another one more judgment, Milord.
For what?
For this compensation.
No, compensatory cost I have not considered. I have not considered. I shall not hear compensatory cost because that is the merit of this matter. I shall not enter into the merit.
At my running in submitting to your lordship to make the one test time to raise your lordship by the point which I have also
Very simple question is there.
Yes,
In review application, whether a court can alter its conscious finding. This is the only question.
on that
Whether a review can be filed, disguise and appeal.
but on that
This is
point,
the observation of Supreme Court in different judgments up to date since Mayavati. There are several, at least 20 or 30 judgments are there on the review, including the recent judgments of 2023 by the Honorable Division Bench of the Supreme Court.
Which cannot
the only on that point, my lord, he will
Yes,
ready to satisfy. Only give him to 2 days.
yes, I am giving you 2 days.
My lord.
Yes, anything from you?
Milord,
kindly-
only submission with regard to the review is not maintainable, my lord.
Very,
You should have preferred an appeal with regard to this.
very.
Only mistakes apparent at the face of the which has fallen from your lordship.
Please take down.
Sir, kindly fix the matter.
Yes, I am fixing that. Decision review application filed by the petitioner. Challenging the finding of this court challenging finding of this court dated 20th August 2024, passed in CO number 2874 of 2019.
The 279, 879, I think. So. 2879.
2874
2874, Milord.
2874 of 2019. Full stop. The learned counsel for the respondent raised the challenge of maintainability. On query, learned counsel for the petitioner submits that this court has not awarded the compensatory cost which was specifically pleaded by this court by the petitioner. He submits that he shall produce the authority wherein this court in review jurisdiction can entertain the plea, wherein this court in review jurisdiction can entertain the plea of payment of compensatory cost, which was earlier denied by this court in the impugned judgment. On such court, he seeks accommodation for 2 days. Accommodation to place the relevant judgments. Let the matter appear in the list on 3rd of March.
My lord,
After the
3rd of March, my lord, I have a matter before the circuit bench, my lord. If this can be this week, my lord.
This week means it may be heard tomorrow. Otherwise,
Tomorrow.
not tomorrow. At best tomorrow, otherwise 3rd.
Third or
Fourth.
fifth,
5th, my lord, 5th.
Yes, come on 5th.
my lord.
Great.
Fifth.
Another heading to mention. Next.
My lord, in this matter, I am for the applicant. My lord, last occasion, your lordship directed my learned friend to give this order, to put this matter today for giving him a last chance to produce the stay order or anything else.
My lord, the
My
matter
lord,
has been.
so far my knowledge, let me finish. So far my knowledge goes, my lord, last week they have given me a notice on Thursday or Friday. Since I was not present, my junior was present. My lord, they have received it, and my lord, they mentioned the matter tomorrow, yesterday, for inclusion. Since the matter is posted today, and mentioning was taken, but the matter was not listed, and so far my knowledge goes, my lord, this will continue. My lord, so my lord, at this stage, my lord, I pray, my lord, this is a my lord, tactics, protractive tactics to my lord, the deny your lordship for a long time to file the appeal. They have filed the appeal since long. My lord, after the my lord, order has been
They have
passed,
mentioned that before
my
the
lord,
division
only
bench.
mentioning they are taking any steps.
No, whether
My lord, they are, your lordship kindly see,
want-
in
you
August,
want an order to impress upon the division
your
bench.
lordship's order is very specific in this. Why, my lord, I am saying so. Your lordship kindly come to once.
You cannot.
No, my lord, I am not praying anything. Your lordship kindly come to page 34. Page 34, once. Please, once, my lord. I am requesting your lordship to come to,
That
come
of what?
of my contempt application. Page 34. The ordering portion of your lordship.
Yes.
My lord, paragraph 29. State authority is directed to give approval of the petitioner as state-aided college teachers category 2 as per memo dated 23rd December 2019 with effect from the date when such decision shall be taken by the concerned authority. So, your lordship thereafter framed that the decision will be taken within 8 weeks. So, the order was passed from August. So, within 8 weeks, they can already move the appeal or anything can happen. They are only filing the appeal. They are sitting tight about the appeal. So, from August, it is September, October. Now, we are in February, last of February. So, even if I win the division bench, if bars, even if, then my lord, as per your lordship's order, the decision shall be taken. So, I will be denied for the benefit for 5 or 6 months. That's why, my lord, I am praying. Let them take in an undertaking
At the
before your
time
lordship.
you will approach before the division bench at the time of hearing.
What can be said, my lord?
The
What
division
can
bench will pass the
if
necessary order.
either division bench, since I have not preparing any appeal.
On appeal has been prepared. And
Yes,
they
yes, my lord,
mentioned
I know, but
the fact.
Supreme Court says
You have to
only,
sit tight
my lord,
by-
your lordship knows better than me. Supreme Court says only filing of appeal does not stand
No, they have
true.
mentioned it. You have said they have mentioned it.
My lord,
for
this
listing
is
the
also
matter.
this is also the point before the Supreme Court.
No, however, the single bench.
I am
cannot
not
press
saying
the
so. I am
division
not.
bench.
I am not saying so. But
No,
why
no,
I am
that
requesting your lordship kindly give a specific time by which they can come.
Specific time, at least the decision be taken by the division bench.
Yes.
How can I praise the division bench to take a decision?
No, my lord.
Then-
I only pray your lordship kindly
No,
fix the
no.
matter 2 weeks hence or
If I pass any such order, they will place the order before the division. That is the pressure upon the
no, my
division
lord.
by
No, my
a
lord. I am not
single
saying
bench.
so.
What would be the interpretation of that?
No, my lord. I am not saying so. I am
Then-
what I am on. Your lordship kindly
That's
fix
why
the matter. Anything.
if an appeal is pending, the first court of the first court pass the order should be restrained. There should be restraint. Judicial
No, my lord.
restraint is
My
there.
lord, in this respect, I simpliciter says the Supreme Court denies this. Supreme
No.
Court denies each and everything of
Matter
this.
is there.
Only
before the
preferring
division.
appeal
That is not
without
the
any stay order.
you are there. You are there. You can pass the. You can place before the division bench. To matter can be heard together. Heard earlier. You are also there.
My
You are
lord,
before the
my lord,
division
so
bench.
far, this division bench is concerned. I am not.
That is not the
referring to.
other way. No,
I
no,
am not saying so.
You have
My
not
lord,
to say anything.
in
I am
one,
not hearing anything regarding.
no, my lord, what I am on. It is just my lord, out of record, my lord.
No, no.
My lord, I am.
You are on here. No, no, nothing.
My
Nothing.
lord,
else.
only this
I
respect.
shall hear nothing regarding division bench.
No. I am not saying anything. My lord, so far, my experience in this regard, my lord, I am mentioning one matter on behalf of the respondent to hear out the appeal. Division bench says simpliciter with notice to the appellant that my lord, this matter, if your lordship can be taken up. Division bench says, what is your account? You can prefer appropriate. You can go before appropriate for pray for implementation of your order. Simpliciter refuses by time.
May I?
What has fallen from your lordship? I just express my view.
Malad, what we have got, I personally mentioned, Malad, very shortly it may be taken up. Malad, it is likely to be taken up. Malad, what I have read from the bench, subject to correction, Malad. So, Malad,
Let the hearing start there.
yes, it will be done.
Let the hearing start there. I'll fix the matter on April. Okay.
By
March.
this time, Malad, it will be
March, your lordship kindly March.
March is next week is the March. What is
No,
the-
my lord, I'm last week of March.
Then first week of April, it is the better. Okay, let the matter appear in the list in the first in the daily in the monthly list of April.
No, my lord, no, my lord. Your
I'm
lordship
grateful,
kindly
my lord.
fixes as to be mentioned. Otherwise, matter could not be heard.
You want the specific date?
Yes,
Very well. 8th of April under the heading 2 women.
I'm grateful.
get
Let the matter appear in the list on 8th of April under the heading of 2 women.
I'm grateful.
Yes. Next.
My lord, only one typographical mistake has to be corrected. Page number 3 of the order. It is mentioned MAT 1543 of 2004. It will be 2024.
This matter appears for correction in the order dated 28th of August 2024. In the first paragraph, page 3, first paragraph of page 3, the appeal number should be correctly read as MAT 1543 of 2024 instead of MAT 1543 of 2004. Remaining portion of the order shall remain unaltered. Remain unaltered. এটা লেখো আজকে। Next.
Shall I appear on behalf of the state, your lordship?
My lord, almost same, but here correction is quite long. Kindly see first page, second paragraph. None appear on behalf of the state. It is correct. Now come to the second page. Second and third paragraph. This should not be here.
What is your difficulty?
No, my lord, as state advocate has not appeared despite serving. So how we can say that learned advocate for the state?
Let
has
it be
to-
there. Let it be there.
Okay, okay, okay.
Yes, next.
Item number 30.
The petitioner led by Mr. Vidal, is affidavit of service. Petitioner's father was a fair price shop dealer. He died. Then the petitioner applied for license on compensation ground.
Who is the father of the petitioner?
Vijay Kumar Mondal, Lordship.
Vijay Kumar Mondal, yes.
That's the license at page number
Vijay Kumar Mondal, when expired?
expired on, Lordship, 12th July 2007.
2007 he expired.
7, Lordship.
Yes, then what happened? Then what happened?
Thereafter, Lordship, the petitioner applied
Petitioner applied for compensation appointment.
compensatory appointment. Lordship.
When?
In the year 2022.
2022.
Why so
That's it,
so
before-
late?
That's it. Before that, the daughter-in-law applied for the same. That's it. Thereafter, it's come.
Yes.
My lord, page 74
year
is the
2000
recent order passed by the authority in connection with
That's it. Page 4, para 7, Lordship. Subsequently, the death of the dealer, FPS dealer, his wife Nirmal Mondal and daughter-in-law, namely Paramita Mondal, jointly applied on 14th January 2008 for obtaining the FPN's license.
You
on
are reading
ground.
page
4, Lordship,
paragraph?
paragraph 7.
Yes.
Relevant document. Subsequently, the said Nirmal Mondal and Paramita Mondal withdraw their application on 3rd April 2012. But the said prayer was, Lordship, rejected by the concerned.
Yes.
Thereafter, they prepared an writ petition, Lordship, being number 607 of 2024, 2014, Lordship. That writ petition was disposed of on 15th July 2015. There is a direction, Lordship.
No, I understand their writ petitions and everything is going on. They are fighting with the authority. That is the other issue altogether.
but my-
Why you were come late?
Lordship, before that, the wife of the dealer and the daughter-in-law, they jointly applied before the concerned authority.
If they unsuccessful, you applied for. So you are the fence sitter.
That's why I have applied, but the department rejecting my application.
Rejected.
my lord, kindly come to page
By
74.
directing page 74, Lordship.
Page 74.
74.
They have given you a hearing.
Lordship, kindly come on page 75 on scrutiny of the case record and considering the submission of the applicant in the light of the WBPDS of 2023, it is found that the erstwhile dealer Vijay Kumar Mondal died on 12th July 2007. The applicant Kavita Mondal, married daughter of the deceased dealer, did not apply for FPS license on compensation ground within reasonable time. Rather, she furnished a declaration on no objection through affidavit affirmed before a notary public in favor of the proposed partnership FPS of her mother Nirmala Mondal and sister-in-law Paramita Mondal. Finally, she was submitted application on 28th September 2022. After about 15 years from the date of death of her father, the applicant could not explain the reason behind inordinate delay in submission of her application. In my consideration view, submission of an application for compensatory appointment was APS dealer cannot be allowed after so many years. For granting of APS license on compensation ground is clearly set out in the West Bengal Public Distribution System Maintenance Order 2013. The applicant has failed to submit application in due time in compliance of the said control order. Moreover, the argument of defense submissions of the applicant is not tenable as she survived all these years without any earning from the APS of his father. APS license on compensation ground is a larger offer by the government and cannot be claimed as an inherited right of the family members of a deceased incapacitated dealer. As such, the instant application of Srimati Komita Bandal is hereby rejected. The APS channel is directed to take necessary action for declaration of the resultant APS vacancy arising out of the death of the Vijay Swanshan. Also, my application was rejected on this ground.
So what is your ground here? Like,
Clause 26 as amended in the year 2020, the maximum time period is submitted within 90 days from the date of death of the deceased, provided that the licensing authority may, on just and sufficient ground shown by the applicant and for the reasons to be recorded in writing, accept such application up to 120 days. That is the maximum limit.
total 150 days.
Yes, 120 days.
Total 150 days.
That is the maximum limit.
Total 120 days. Yes. What is your ground in the writ petition?
So, before that, the mother and the daughter-in-law, they are applied lordship. There are so many writ petitions has been going on before this Honorable High Court. That's why I'm led by Mr. Huda lordship. Yes.
Yes. How the order is arbitrary? Okay, you take your
Lordship.
breath. Just wait.
Kind of 759 minutes from one end to the other.
Take your breath first.
Lordship had heard this, but I would say substantially, this writ petition, though being moved for the first time, but the facts were agitated, in a prior writ petition, So Lordship is aware of this, substantially aware of the facts of the case, and application, for appointment of the dealer on compassionate ground, before I take your Lordship, to the impugned order, which is under challenge, may I, very quickly, take your Lordship through, some of the documents, and I shall answer all your Lordship's queries.
I have already gone through the documents. What is your ground to challenge the impugned order? Why you challenge the impugned order?
So far as the reason of delay is concerned, Lordship will kindly see, because this was an application.
I have directed the authority to hear out and pass a reasoned order.
Yes.
They have given the opportunity of being heard to all the parties.
No, not after your Lordship's order.
After this court's order, they have given you the opportunity to have hearing.
No.
And pass the order.
No, not after the court's order. But then I'm not disputing that. I am not on the hearing opportunity not having been given. I'm not on that at all. After your Lordship's order, because this application, was made in 2022, in 2022. So, last time when we came up, and after this, I have been given notices, for hearing. Hearings have been conducted, I have been asked, my lord, to submit certain documents, sir. Those have also been done. Everything is done. Had that been the case, my lord, of delay, my lord, then, my lord, the very first time that I had, my lord, filed the application, my lord, should have been, my lord, dismissed then and there. But, my lord, there were reasons as to why it was not dismissed then and why your lordship had, my lord, allowed this. I had given this order, my lord, the last order on that date, my lord. Now, if your lordship, my lord, comes to, because I have appeared for hearing, my lord, at different levels, before the sub-divisional, before the district controller, and also before the director.
Yes.
Now, if your lordship comes, my lord, your lordship's last order, which is at page 71, and on that date also, my lord, lordship had seen everything, all the documents. Then, your lordship had, my lord, given these directions at page 71. It appears that the authority has already heard the petition on 7th August 2024. No decision has been intimated to the petitioner. Considering the long silence of the authority, I take it necessary to pass a direction to the concerned respondent authority to place a report in respect of the legislature. So, my lord, they were, my lord, directed to place a report as to what is the status report, what has happened. My lordship sees, my lord, this order was passed on 27th of January 2025. And if your lordship turns over page 73, my lord, is the order under challenge, which was received by me on 29th of January. They had called me in their office, and, my lord, I went there, and this order was handed over to me. If your lordship sees, my lord, the letter, my lord, from the joint director license is dated 4th of October 2024, much before this order. And in fact, the order was passed on 17th September 2024. So, had I not come before your lordship, and had I not, my lord, filed the writ petition, my lord, and had your lordship not passed this order, my lord, perhaps I would have been in dark forever. Now, lordship comes to the impugned order. Kindly comes, my lord, to page 75.
Yes.
On scrutiny, my lord, I'm reading the last paragraph. On scrutiny of the case record, on scrutiny of the case record and considering the submission of the applicants in the light of, well, the control order, it is found that the erstwhile dealer died on 12th of July 2007. The applicant, Kavita Mandal, married daughter of the deceased dealer, did not apply for FPS license on compassionate ground within reasonable time. Rather, she furnished a declaration of no objection through affidavit affirmed before and so, Lord, on 28th of September 2022, that is, after about 15 years from the date of the death of the father. The applicant could not explain the reason behind the inordinate delay in submission of her application. Now, your lordship turns over, my lord. In my considered view, submission of an application for compassionate appointment as FPS dealer cannot be allowed after so many years. So, my lord, the reason as to why it was delayed, my lord, is why it was rejected, my lord, is the reason of delay. Now, if your lordship, my lord, comes to, my lord, the list of date ones, my lord, because that is the easiest way, my lord, to understand as to why this delay had occasioned.
The litigations between the authority and the lady, that is the widow, and his son and his daughter, like that.
That is because
Petitioner was not the party.
correct. That is because, my lord, there were my lord, the first application died in 2007. 2008, my lord, the first application was filed. Now,
So
who had
what
filed?
is your status there? You have not applied for.
Nothing
be,
diverts
that is
the petitioner from applying.
Yes.
the reason, my lord. I was completely dependent on my father. Otherwise, I could not have made this application. Since I was completely dependent on my father had expired, my lord. So I, my lord, started to be dependent on my brother. I had nowhere to go to. Unemployed. 2008, my lord, the application was made by, my lord, the mother and, my lord, the wife of the my brother. But I could not have dared, but at that point of time, to say no, I will file the application, because otherwise that, my lord, would have been absolutely, my lord, prejudicial on my part, because I was completely dependent on my brother. Now, my lord, this continued 2008, my lord. Then, my lord, 2012, my lord, another application was made. In 2014, my lord, a writ petition
That
was
means
filed.
you are not solely dependent upon your father. That's why you are not applied for.
No, I was dependent on my.
How can one authority allowed one after another relative to allow and you filing applications after applications, after 15 years you have come.
No, no, I am not on the authority allowing or not allowing and who could have applied, who could not have applied. I am trying here to explain the delay. And the delay is for appointment on compassionate ground. The word itself.
Appointment for compassionate ground in respect of your candidate.
Yes, my lord. Now, Lordship, my lord, kindly, my lord, envisage the situation where
no, I understand.
I am completely dependent on my brother.
As your mother and the brother's wife has failed, you again file on application. This is the situation.
No, but
as
I am
they
not
have
a
failed, they have come down, and they have lost the writ, and you have filed again another litigations.
No, I am not, my lord. But Lordship will kindly also appreciate this, that even till today, my lord, there is no publication of resultant vacancy.
Let the
there is not.
Let the proceed.
There is nothing, my lord.
There are questions of like
there is nothing, my lord. My lord, could not have dared to file this application. Because who was filing the application? My brother, on whom I was completely dependent for my existence, because I am unemployed.
That means you are not required any license.
No, because the condition is that the person applying has to be dependent on the license holder at the time of his death. And that is, my lord, my categoric averment in my writ petition, that I was completely dependent on my father, who was the ration dealer.
How can it be you? So you are 50 years old now. At the time you were major, you can file it. 40.
No, Lordship will kindly, my lord. 40, the explanation, my lord. Lordship will kindly come to.
Years, and you are married person, I think.
Yes, married.
Then.
But just because I'm married, my lord, does not stop me from making an application. My husband himself, my lord, is incapacitated. That is, the averment is there, my lord, and it is, my lord. Lordship will kindly come to, my lord, paragraphs 8 and 9. I will just read, my lord, please, paragraphs 8 and 9, my lord. Only paragraphs 8 and 9.
You are a fence sitter. You were just sitting there and looking the litigations. Thereafter, you jump up on the
what else? Well, what else could I have done? Had I, my
you
lord,
have to file an application for compassionate appointment, and you have gave the no objection. Now you are coming with the
correct, my lord. But that would have, my lord.
No, whether you can file you file no objection, and again you file for the post, where you have given the no objection.
Why was, what was the reason, my lord? The reason was,
whatever may be.
But you kindly gives me 2 minutes, my lord.
No, just you satisfy me, not regarding the reason. One declaration of vacancy is there, one running vacancy is there. You may apply for the post. At that time, you denied to participate by using no objection. Now, whether you can allow to participate or apply for the life post.
No, my lord, everything now depends on the reasons and the circumstances.
No, not the reason.
Lord, had I then applied, my lord, that would have amounted to rebellion. I would have rebelled against my brother, on whom I was completely dependent. And my lord, so far as compassion, my lord, the heading itself says, my lord, compassion. The heading itself, my lord, compassionate appointment, my lord. Now, my lord, Lordship will kindly, my lord, appreciate this, my lord. 2 minutes. Kindly appreciate this, my lord. But as petitioners, my lord, we approach a court, my lord. My lord, the reason being, my lord, that, my lord, this court, my lord, is a court of, my lord, equity, justice, and good conscience, my lord. So far as justice is concerned, my lord, Lordship will kindly see the control order. The control order itself gives preference to, my lord, the legal heirs of the deceased dealer. My lord, so far as, my lord, equity is concerned, my lord, I have, my lord, NOC from all, my lord. My lord, I am the daughter of the deceased, my lord. I fulfill all the criteria, my lord. Lord, I could not have made the application because that would have amounted to rebellion, my lord, against the person on whom I was completely dependent.
So there is a conscious decision of your family that this person shall apply for the license. Now you have also taken a go by stand 180 degree and taken the no. As they have failed, I would be allowed to take the license.
Person who had applied.
No, that is not the purpose of writ petitions.
But the person who
had applied, you have taken a conscious decision.
Yes.
You are the major.
Yes.
You have taken a conscious decision that from amongst 12 persons, this person shall apply for the license. And you have given the no objection. Now you have come against before this court. No, as they have failed, they have denied by the authority, I can file the application.
Not just as they have failed. As they have failed, and there is no publication of resultant vacancy, and I am one of, my lord, I am one of the legal heirs, my lord.
Once you consciously avoid it, now you cannot again allowed to pray for the license.
That was absolutely, my lord, circumstantial, my lord. But
I understand
had
the
I-
circumstances.
had
I
I applied-
understand the circumstances.
Had I applied, my lord, not
But legally, you are not allowed. I understand the circumstances. I understand, sir. You are the daughter. You are the person who are dependent upon all your brothers. Maybe not regularly dependent, but you have to go by the decision of the family. You have to go by the decision, and you gave the no objection. When you given the no objection, whether legally such no objection can be turned down?
that is correct, my lord.
Your no objection.
Legally, my lord, I may not be on that good footing, my lord. Justice. But
Yes.
there are three parts of justice, my lord. My lord, three parts of my lord, court's order, my lord. Justice, equity, good conscience. I am on good conscience. I am on equity, my lord.
No, no.
Legally,
You
my lord,
cannot
I
say
may not be
equity.
standing on a very good footing, my lord.
No, no.
But
You
my lord,
cannot
lordship
speak
cannot, my
equity on
lord.
that points.
My lord, lordship cannot brush aside, my lord, the concept of my lord, equity and good conscience, my lord. On equity, if your lordship sees, my lord,
No.
I am
what
unemployed,
is
my
the
lord.
equity you want?
My lordship,
What equity you want after 15 years?
my lord, equity.
What equity you want?
my lord,
You
on
have
the
proceeded with
basis-
the equity so that your one of the brother can get the license.
No.
Now you are appearing before this court. No, no, forget about give me the license.
No, brother.
What is your stand?
Sister-in-law, my lord, of
Whatever may be, one with the family member of your part.
I have
Yes.
explained everything, lordship. Lordship
Very.
feels, my lord. If I have a case, my lord, lordship gives the order, my
Very,
lord.
very.
Otherwise, my lord,
Okay.
because I still remain, my lord, unemployed. I still remain the legal heir of the deceased, my lord, and there is no resultant vacancy, my lord. Had there been a publication, my lord, perhaps I did not have a case. But everything as on date, my lord, is status quo. Status quo as it was on the date of the death of the deceased dealer, my lord.
Very.
Everything remains the same.
Okay. Yes, anything?
No, my
You will
lord,
kindly
from your lordship, I am adopting.
I am, Lord. I'll be praying for some compassion, my lord, for this
Very well.
compassion appointment,
Okay,
my lord.
okay. Please take down.
But may I, my lord?
Yes. Challenging a reason order dated 17 September 2024. The petitioner, reason order dated 17 September 2024, passed by the director DDP and S. The instant date petition has been prepared. Full stop. It is the case of the petitioner that the father of the petitioner, namely one Vijay Kumar Mandal, was one of the FPS license holder who expired on 12th of July 2007. The petitioner applied for license on compulsion at permanent on in the year 2022. His applications was not considered. Accordingly, he approached this court. This court in WPA number 881 of 2025, with the order dated 27/1/2025, asked for a report from the concerned state authority. However, the state authority has obtained has passed the order on 17th of impugned order 17th of September 2024. Mr. Sayyadi Huda, learned counsel appearing on behalf of the state of on behalf of the petitioner, submits that the present petitioner was solely dependent upon the income of the deceased, income of her father, within bracket deceased MR dealer. He further submits that the widow of the Emma dealer, that is the mother of the petitioner,
Not first time, my lord. First time mother and my lord.
mother and
My lord, this the
Momita Mandal and Pratima Mandal,
is the my lord, my sister-in-law, my lord.
sister-in-law. Mother and sister-in-law applied for the license. And sister-in-law, daughter-in-law of the deceased dollar, sister-in-law, কি বললাম বলো? And one daughter-in-law of the deceased dealer, namely Pratima Mandal, applied for FPS license on compassionate ground. Applied for the license on compassionate ground. Their license, their pair was rejected. Being agreed by their rejection, they have approached before this court in writ petitions, in a writ petition. There are certain other litigations between the authority and the family members. Finally, the prayer of the family members for getting license under compassionate appointment was turned down. For getting license under compassionate appointment was turned down. It is further contention of the learned counsel for the petitioner that the present petitioner was solely dependent upon the father, upon the deceased Emma dealer, and after his demise, she was solely dependent upon the brothers. At the time, as the other family members had applied for the license, she could not apply for the license on compassionate appointment, considering the family decision. It is a further case of the petitioner that petitioner is a person who was solely dependent and solely dependent upon the income of the deceased Emma dealer. And at present, no resultant vacancy has been declared by the state authority. We further argued that the present petitioner, being one of the legal heirs of the deceased Emma dealer, is entitled to get the license. Mr. Huda admits that there may be some delay in filing the applications, but the reasons thereof regarding filing applications in delay has been specifically assigned in the writ petitions. He submits that though the application was filed in delay, it may be considered. Having heard the learned counsel for the parties, it appears that the reason order dated 7th of September 2024 has assigned the reasons for not considering the candidature of the present petitioner as follows. Page 75 করুন, এইখান থেকে on scrutiny থেকে বললাম, এখান থেকে page 75 of the writ petition করে 76 এ শেষ করুন। হচ্ছে From the facts and circumstances of this case, it appears to me that the writ petitioner Kavita Mandal is married daughter of the deceased dealer who not applied for the license on compassionate ground, rather filed no objection in favor of the applicants who are the family members. Now as their application were not materialized, the present petitioner has applied for the license. In my view, there is a long delay in filing the application for getting compassionate appointment. First of the status of the petitioner can be very well considered to be a fence sitter present petitioner can be considered to be a fence sitter who was sitting over the wall and sitting the litigations and observing the litigations. After litigations are over, the petitioner jump over the spot and applied for the license. In my view, the petitioner, being a fence sitter, cannot be allowed to apply for a license. In my view, petitioner, being a fence sitter, cannot apply for the license, which he has already denied by declaring no objection through affidavit affirmed before the competent authority. In the writ petitioner, the petitioner cannot claim equity what she already denied to obtain. Under the above assumption, I find no justification to entertain the writ petition. According to the instant writ petition is disposed of, being devoid of merit. Affidavit of service filed on the petitioner is taken on record. Next.
Could I appear on behalf of the state, Your Lordship?
Yes.
This is one of those vacancy
matters.
Lordship can pass the issue.
Where is the license? It is up to 2023. Whether it
Your
is
Lordship, it has been renewed. I have instructed.
they are running in
His
the
license is valid till 2026.
What is the vacancy notification?
Vacancy notification, Lordship will find
Page?
Yes, my lord. Page 29.
Page 29.
29, my lord. The type copy is
area
29.
you are
Yes, yes.
in the said area.
Yes. Representation at page 30.
Similar direction. দেখলো আগে থেকে হয় যেগুলো মনে আছে কোনটা আগে MAT 1543 of 2024.
But the affidavit of service, my lord.
Yes, affidavit of service file has been taken on record. Next.
I am for the petitioner.
Yes.
Seeking a day's accommodation, my lord. You have received instructions in the matter.
I have no
But my lord, on the
difficulty, but
second thought, I was just going through the writ petition, my lord. I was my duty is to indicate to your lordship whether lordship has got the determination to take it. My lord, arises out of a challenge, out of a tender. That's under group 9. So it will come under group 8 or not, my lord. Similar writ petitions had come before this honorable court and was adjudicated before the group 9 determination.
Well, this is my lord. Kindly
Same
turn to
identical facts, my lord.
page 40. Your lordship had numbers of cases. Tender for transportation of bulk petroleum product. This is coming under the group 8 as the, my lord, Petroleum Act. That's the issue. Your lordship had so many
whether it is
cases.
group 8 or group 9. That is
Group
the-
8, because my lord, this is not the transportation. Petroleum product.
But this is arising out
But
of
MR
a
distributor is carrying, my lord, rice and
taken in
wheat.
a cancellation of a tender. My learned friend is challenging his rejection in a tender. Whether I am very well ready would be obliged to address your lordship, but it is
Otherwise,
my
it will go
duty
without
at the
jurisdiction. If it within
yes,
my
yes, at the
jurisdiction,
threshold to indicate. Otherwise, at
That's
the
what I am saying.
future time, lordship might fail that. Why did you not indicate?
MR distributor carrying rice and wheat, license cancel, tender. Where I shall go?
Group 9, my lord.
Group 9, he is saying group 9. So MR dealer, MR distributor, all will go through the
It's
group
not
9.
an MR dealer.
This is same. No,
license
no.
cancel.
I have been selected. Subsequently, my selection has been withdrawn. Subject to a lordship consideration, if lordship allow me
Selection for what?
for carrying my lord
Tender was
petroleum
being
product.
floated.
For carrying.
For
Petroleum product.
A tender was being
Transportation.
floated, my lord, for
Yeah, my-
transportation of tank trucks.
Okay,
For giving tank
transportation.
of tank trucks by HPCL.
Okay,
But he
group
has
9
been
is there.
No, kindly
he has
come to
been
page
rejected,
40.
my
My
lord. He
landed
has
is not
challenged
offered.
the rejection order.
My duty is to transport the petroleum product. It is come within the 100 of
I
cases.
have heard several matters from group 9 on that point.
Group 8, always group 8. Your lordship also heard this matter. So far the judgment has been delivered. My learned friend appeared. Kindly consider same issue. Just 2 or 3 days back, your lordship delivered a judgment. Where my learned friend also. The same issue was pending before your lordship.
In that matter, issue was.
I don't know why my learned friend today raising this voice.
No,
Kindly come to the tender note document, page 40, page 40. I cannot go before the group 9 because this is a Petroleum Act 1913. In that case, my lord,
I have heard some such type of matters regarding tender process of
LPG distributor,
transportation of group 9 matters. While I was in charge of Mr.
Your lordship, kindly consider my
Rai
lordship.
Chattopadhyay's
If that is
resignation.
so, if that is so, a transporter of petroleum product, it goes to the group 9. Then MR distributor business will also go to the group 9. Why I am saying so? In that case, a vacancy arises. I applied for. Subsequently, my application may be rejected. My duty is to carry the rational articles. That's the only issue.
Group 8 is in the matter coming under the Essential Commodities Act.
Petroleum product.
So,
Essential.
the tender of essential commodities, whether tender means
MR
transportation.
distributor is also my lord, tender issue.
No.
Vacancy.
No, that is the other tender, that is the license is concerned, that is the issue.
This is also license.
What is the transportation of the issue is
What is the duty of the distributor? Transportation of goods, delivery to the goods to the dealers. Same issue. Kindly see what is your lordship jurisdiction. This is a petroleum product.
No, petroleum product is essential commodities, that is not the issue. That why the license of IOCL and everything is under
Yes,
license.
yes.
That is the
So many cases your lordship had, my learned friend also appeared. Possibly, my lord, last week your lordship passed an order on the same issue. Same issue was involved. Why my learned friend today is taking this plea? Because there are some urgency. He first, subject to your lordship consideration, prayed for an adjournment today.
But
that is the altogether separate
my
issue.
duty to indicate to your lordship, my lord, because identical facts were before this honorable court on same cause of action. They are adjudicated by the residuary bench, my lord.
And your lordship has considered group 8 matter. My learned friend appeared. Matter number.
This
Your
arises
judgment
out of a tender.
Whether
or
if any
supply
order
of
passes.
tank trucks. My lord, supply of tank trucks. This has nothing to do with petroleum
Supply
product.
of tank trucks.
Supply of tank trucks in a tender floated by HPCL, my lord. My learned friend had offered tank trucks. He has been rejected in the tender.
Kindly turn to page 40.
This is the
What is the tender? Kindly turn to page 40.
of the matter in issue.
This issue is being raised before your lordship. I don't know. He may not choose this court, but this issue should not have been raised.
No, that is
Kindly come to
not-
page
my lord,
40.
I am concerning about the
Kindly come to
whether
that.
this
What is
order would be infructuous
kindly
or
come to page
without
40.
jurisdiction. That
Kindly
is the
come
only
to page
question.
the tender.
No, whether this can be heard today or
Yes,
tomorrow.
Tomorrow, lordship fixes it.
Come on, tomorrow then.
Only difficulty yesterday we mentioned this matter because the L1 bidder is in the pipeline. L2 bidder. I am the L1. At least one at some assurance from my learned friend that today they will not do issue the appointment to the L2 candidate. That's my only because we mentioned this matter yesterday. Considering urgency, ownership, fix it matter as mentioned
We
matter.
were never served a notice, my lord. My learned friend knows, my lord. In all HPCL matters, I generally appear, my lord. Notice ought to have been served, my lord. Otherwise, I would have indicated.
Very good. Come on tomorrow. Come on tomorrow.
My lord, may I say one thing, my lord? Tomorrow 10:30 matter is fixed. Can it be, my lord, after 10:30 matter?
10:30 which matter please?
Mr. Bandapathy is appearing. I also appear. So, but the review application is concerned.
After this matter, it will be taken.
No, this matter may be taken up after review. Otherwise,
Yes.
so
This matter will be taken up as a second matter.
second 10:30.
Second.
Very.
I'm good.
Oblige, my lord.
Yes. Next.
Item number 89 for the petitioner, my lord. My lord, in item number 18, a supplementary affidavit is required to be filed. My lord, there are certain documents which are necessary for proper disposal of this case, which has been missed out in the writ petition. My lord, I want to file a supplementary affidavit. If your lordship kindly grants me 2 days' time.
What is the matter about?
My lord, it is the matter where the HPCL, dealer of HPCL, I approached the dealer of HPCL for partnership business, and I have been cheated. That is the crux of the matter. I have come before your lordship for relief.
So what document you want to adduce
My
or
lord,
want
that
to place?
HPCL was all along in the know of the fraudulent conduct of the dealer. And HPCL has always motivated the dealer by not taking any action against the dealer for these kind of acts and actions they are conducting.
So it is dispute between the dealer and yourself. Why
But
you?
it is the dealer of HPCL, my lord. I have entered into the contract for entering into as a partner of that dealership business, seeing that it is a dealership business of HPCL. Had it not been a dealership business of HPCL, I would not have approached the petitioners, my lord, respondents, my lord.
The agreement was done in an individual capacity by the third party, my lord. And obviously, they filed an application for reconstitution, but at their own desire, they withdrew the same. Now, we have no power and authority to force somebody to get into the partnership or have the dealership.
So
They
what
are
document
making
you
some
want to
thought.
produce? Okay. What document you want to produce?
My lord, the letters that I have written to the HPCL complaining of the things.
Next Monday. Let the matter appear in the list under the same heading.
Monday, month combined list. So it would be, it appears in monthly list, then very well. Otherwise, on
My lord, it's Tuesday.
It's better to come up.
Respondent number 7.
Private respondent number 7. 4th March.
My lord, I'm deeply obliged, your lordship.
Your lordship,
But I'm for the petitioner, my lord.
your lordship, the exception has not been served.
Lord, this is exception. My lord, this is my exception, my lord. Herein now I am serving now.
Yes, what is the writ petition about?
My lord, the writ petition is about, my lord, grant of fair price ration shop, my lord. The petitioner applied for the fair price ration shop license, and thereafter there was a silence on the part of the authority. Then the writ petition was preferred, my lord. And then in the, if lordship may kindly come to their affidavit, the report in the form of affidavit which they have filed right now, my lord. Lordship may kindly consider.
No, what is the prayer in the writ petition?
Prayer, my lord, to issue the license in my favor.
Your favor?
In my favor. Because I am the suitable candidate. Lordship may kindly consider prayer
You
A.
applied for the license?
Yes, I applied for the license.
Your proposed shop come go down was inspected?
Yes.
Yes, your lordship. Your lordship, along with other applicants, your lordship, all have been found ineligible. Your lordship, the authorities are taking the steps for initiating fresh vacancy, your lordship. All the candidates has been rejected, your lordship. No one has been found eligible after final consideration of the committee, your lordship.
Lordship, may I submit one thing? Till date, nothing has been done for re-advertisement or etc.
Steps are being
No,
taken.
rejection order is there at page 40 in respect of your application. Sotin Bormon, rejected.
Lordship.
Lordship, now Lordship may kindly come to their report in the form of affidavit, which they have submitted right now.
Yes, report.
Report in form of affidavit filed on behalf of respondent number 1 to 5.
Yes.
Lordship may kindly consider page 8. Page 8, paragraph 4. Facts of the case, paragraph 4. Non-discriminatory action. Contrary to the petitioner's claim, the actions of Food and Supplies Department and the area inspector were based strictly on the eligibility criteria set forth by the government order. The petitioner application was not rejected due to any discriminatory act or personal bias, but rather due to his inability to provide complete and operational shop come go down as per prescribed requirement. Now, Lordship may kindly come to the same affidavit at page 14. Left-hand side findings. My lord, last paragraph, 65.
Yes.
Last line, the case is eligible. The last line.
No, your proposed shop come go down is under construction.
I mean, yeah, I'm coming to that, but I'm coming to that.
Yes.
Since I have placed the report in the form of affidavit, I will point out everything.
Yes.
During the time of physical inquiry, bank balance as on so-and-so was rupees so-and-so, it's fulfilled geo number so-and-so, the area of the shop come go down is found so-and-so, the proposed shop come go down and shade veranda was under construction, it's not fulfilled geo number so-and-so. The approach road is found 10 feet. After re-inquiry on so-and-so, the shop come go down complete and there is to so-and-so square feet of shaded veranda found. Hence, the case is eligible. If I am eligible, then why I was rejected?
Yes.
First point, my lord. Second point, my lord. Lordship may kindly come to paragraph page 13. এটা তো সেদিনকার কালার ছবিটা কোথায় ওটা আমরা অ্যানেক্স করেছি লর্ডশিপ 1356 paragraph 56 eligibility comments on suitability. During the time of physical inquiry, the shop come godown is found under construction and the area of the godown is so and so. The roof of the godown is made by corrugated sheet. There are no shaded veranda. After re-inquiry on 24, date is very important, on 24/5/23, shop come godown is found so and so square feet. Now, if Lordship may, what number page? Lordship may kindly come to page number 10 of our exception. আমাদেরটা কোথায়? Oh, আমাদের. This is a photograph. GPS map camera photograph taken on 24/5 April 2023. We fulfill the criteria, we are having the godown with shaded veranda.
Your Lordship, the picture does not show any date or any as on the date of. Your Lordship, this is not before the inquiry, Your Lordship. The date of inquiry, Your Lordship will kindly see. Date of application was January 2023. And the date of inquiry was
10th of February 2020.
10th of February, Your Lordship. Your Lordship, in the event there is any discrepancy in the facts, Your Lordship, the authority can at the best reconsider his representation and pass a reasoned order. Your Lordship, the license cannot be granted, Your Lordship. When all the applications have been rejected on the ground of ineligibility.
All the applications were rejected, but in my case, it was found eligible. Why two type of stands, my lord? Either you reject it or you make it eligible. This creates a confusion, my lord. Their report, they are telling, their report in the area inspector is telling that yes, fit for eligible after second inspection. Now in the affidavit, they are taking complete different stand. The total 9 of them are eligible. We will have re-advertise. There is no re-advertisement till date.
Lordship, this is
Sorry,
the
Victor.
inquiry report is merely a recommendation, Your Lordship. The final decision had been taken by the committee. Your Lordship, merely on the basis of recommendation, that does not incur any right upon the petitioner to obtain the license, Your Lordship. The final decision was taken by the committee, where all the
Where
applicants.
is the decision? Copy
Your
of
Lordship,
decision.
that I have to obtain, Your Lordship.
But there is no reason.
Your
The
Lordship,
rejection without any reason.
Your
Well,
Lordship,
if I am
Your Lordship,
if
in a process,
but
license process,
if I am ineligible because of this criteria, why I should be made eligible?
No, you are not man eligible.
Lordship, Lordship,
The inspector who inspected the location,
Hmm.
he have noted the found that the candidature can be considered on
Yes.
this issue. But the
Mainly
decision
can be
has to be taken
considered.
by the fair price sub selection committee. What is the point? What is the resolution? That has to be looked into. They are not the authority. Inspector is not the authority. to
Malay,
decide.
inspector is not the authority. Inspector has inspected. They have submitted. Inspector has submitted a report to the committee.
Report in the pro forma.
A report in the pro forma concerning 65 points or 68 points. Malay,
75 points are there.
70. He has considered.
Your Lordship,
And on what basis it was rejected, that is not
Your
clear.
Lordship, in a license process, Your Lordship, there are 10, 12 applicants.
Yes.
Your Lordship, it is not incumbent on the committee to produce reasons to each
No,
and
no.
every
You must show a reason.
applicant, Your Lordship.
What you are saying, you must show a reason.
Your Lordship, thereafter in tender matter, in every process, thousands of applicants have to be given separate letters giving reasons, Your Lordship. That is not incumbent on the authority, Your Lordship. The authority, the committee thought it fit to that none of the applicants have been considered to be eligible, Your Lordship. That is there in the report.
Malay, they are
given by the
statutory. They are
subdivision
statutory
of
bodies.
the
They must define a reason while rejecting.
Your Lordship, kindly see page 8 and 9, Your Lordship.
Yes, I have read the page 18. What is the data? This is the subdivision control.
Yes, Your Lordship. And the reason has been provided here, Your Lordship, in the report. Your Lordship, kindly sees paragraph 6, Your Lordship. The DDPS has already recommended the vacancy to be re-notified.
What is the decision? How is the orders?
Yes.
There is no such order. You have
Malay, there must be a rejection order.
you have not annexed such orders.
Your Lordship, the report was submitted, Your Lordship. I shall come back with the recommendation order of the DDPS, and the authority at any point of time may choose to cancel a procedure and
Yes, authority has every right. Authority has every right to cancel, but there should be backed by a reason. You are the authority. You can have every right to cancel.
Your Lordship.
But in the report, you have not disclosed the reason.
Here, page 9, 8 and 9 clearly indicates the reason, Your Lordship. If Your Lordship pleases, I shall provide the recommendation of the DDPS and the committee. And it is not his case that
Okay, I'm directing the authority to state him the particular reasons.
Lordship. Lordship, in the meantime, they should not re-advertise, my lord. I need that protection only, nothing else.
How can that be
Whether
possible,
they
Your
have
Lordship?
re-notified?
No, no, no,
Your
no,
Lordship,
no,
the
no, no.
recommendation is already there. The
Till date,
department has
no.
taken steps to re-notify, Your Lordship.
Till date, no, my lord.
But for one candidate, Your Lordship, for a reasoned order, an entire notification process
My lord,
cannot be
my lord,
stalled, Your Lordship.
then entire thing will go. In the meantime, if they re-notify, Lordship give a short time.
I'm giving them short time to.
If he's eligible.
Till such time, my lord, they should not
Your
re-notify.
Lordship,
Till such time,
Your Lordship,
this much protection.
If the matter is being disposed of, Your Lordship,
My lord, I have invested a huge amount of money. Kindly give me that protection. I'm not paying anything else.
Application has
Why
been
you not
rejected, Your
complete the
Lordship.
go down within time?
If
My
he's eligible,
lord, it is completed, my lord, but somehow I could not say anything much. My lord, it was not completed in the first inspection, but it was completed in the second inspection. My lord, first inspection, there was some financial difficulty, my lord, I could not complete it. But on the second inspection, that is on 20.
You cannot be allowed to further.
That is on 20.
Re-inspection is not the way.
My lord, they have given that liberty, my lord.
Why
My lord, in every case, my lord.
That's why I'm facing you to just you go to the
Your Lordship, I
concerned
can-
SCFS and.
I can
My lord, let the decision be produced, my lord.
I can take the point, Your Lordship, that the eligibility
taken
has to be considered as on the date of application, Your Lordship. And as on the date of application, he was not eligible and his go down was.
But you have not taken that
complete, Your
point.
Lordship.
Now arguing that point is immaterial on record.
No, no.
My evidence in opposition, Your Lordship. I'm submitting. This
Okay,
was
hard.
merely a report.
Okay, hard. Petitioner applied for license in terms of notification.
My affidavit of service.
Affidavit of service filed on behalf of the petitioner is taken on record. Petitioner applied for FPS license in terms of vacancy notification number 624 dated 17th of November 2022 issued by the concerned subdivisional controller food and supply. After application being submitted, the proposed shopcom godown of the petitioner was inspected. Firstly, on 10th of February 2023. Thereafter, again on 24th of May 2023. Today 23.
And third on 21st July 23.
There is no such third inspection.
My lord, in the report. Page 3, paragraph C. Third inspection.
Thirdly, on 21st of July 2023.
Yes.
Thirdly, on 21st of July 2023. After such inspections, no decision was obtained by the authority. Thereafter, suddenly, the petitioner came to know from the portal that his candidature was rejected. The authority concerned has not assigned any reason for rejection, so he filed the writ petition. The respondent number 1 to 5 submits a report in the form of affidavit containing inter alia that total 9 private respondents had applied for FPS license, but none of them, including the petitioner, could fulfill all eligible criteria. As a result, none of the applicants were deemed eligible for the FPS license. It is the further contention of the learned counsel for the state that since no applicant was found eligible, the concerned upper authority had recommended that the vacancy may be re-notified. Full stop. The learned counsel for the petitioner submits that no reason has been assigned by the state authority regarding rejection of his candidature. He placed the necessary pages of the report and submits that the inspecting officer, after inquiry, has found the case of the petitioner to be eligible. He further submits that the decision of the authority is perverse and not reasonable. So he prayed for necessary order so that the license may be granted in his favor. Having heard the learned counsels for the parties, considering the report as well as the exception filed by the petitioner, it appears to me that the concerned authority has taken decision that none of the candidates has fulfilled the eligible criteria. However, regarding the candidature of the present applicant is concerned, it appears from the report that the inspector has depicted his finding that the case of the petitioner is eligible. The petitioner may be ineligible on other aspects, but such fact or the reasons has to be specifically dealt with by the concerned SCFS. Under the above observation, the instant writ petition is disposed of with a direction to the concerned SCFS, being the respondent number 4 of this writ petition, to decide the to have you filed any representation with the authority? No.
No. After rejection, no.
Okay. Disposed of with a direction to the concerned SCFS, being the respondent number 4 of this writ petition, to take a reasoned decision.
Grateful, ma'am.
To take a reasoned decision as to why the candidature of the present petitioner was not considered. The present petition is directed to.
Your Lordship, it was considered and rejected, Your Lordship. Not
Grounds were not assigned. That's it. Okay, Bola. Petition is directed to approach the concerned SCFS with an specific application coupled with a copy of this order. The concerned SCFS shall take a reasoned decision within 6 weeks from the date of the submission of the application by the petitioner, and shall by giving a reasonable opportunity of being heard to the petitioner, and shall intimate the decision to the petitioner within 2 weeks thereafter. Full stop. I make it clear that the decision of the authority arrived at has not entered into by this court during hearing of the instant writ petition. It is only at the domain of the concerned SCFS to assign the reason for not considering the candidature of the petitioner. Full stop. Writ petition disposed of.
Grateful.
The people, I think item number 21. Both sides here, I am only for extension of time to file affidavit in opposition. They are enjoying the entry order and
file report, Your Lordship. Report.
Second half, after 2 fixed matters, I will take up these matters. I have 2 fixed matters. If the time not permit, I will take up this matter after that.
Fixed minute to double.
Okay, call the list.
Right. Well, if your lordship recalls, well, this is that levy sugar matter.
Yes.
Yes, well, on the 10th of February 2025, this was your lordship's order, where I had extensively, lordship was pleased to
Yes.
allow us to complete our submissions. And today, Union of India is required to.
Yes.
I'm led by Mr. Devendra and
There are altogether 3 writ petitions.
My lord.
Each
Total
one is
4,
same.
my lord. Total three.
Total 3.
Yes. So if your lordship recalls, my submission was simple. My lord, the price determination of levy sugar is based
Regarding
on
crushing capacity. Regarding
capacity
crushing
and capacity.
Yes.
And we say here there is no issue regarding.
You have the crushing capacity 800 to 1200.
Correct. I have a license capacity of so much. Now, based on certain letters that I had written, they say that you have the capability to crush more than 1200.
No, you have issued the letter. You have written the letter to them to enhance your capacity, but they have not accepted your proposal. They turned down your proposal.
Right. And
on the basis of that letter, they are saying that you have the capacity to crush more than that, so you are not within that category.
Correct. You are not. You are a efficient category, not a less efficient category.
Not less
Correct.
efficient.
Correct. Great, deeply obligable. And well, the 2 judgments that I relied upon, in particularly the Delhi High Court judgment,
Yes.
which specifically clarifies that licensed capacity. What is the authorized license capacity? That needs to be taken into consideration. Not now, if the other way also, like suppose today for some reason my machineries are broken down, damaged, I don't have the money. So from 1200, I may be doing 500. Or say I had license capacity of 2000. That's the example I had given. 2000. So I fall under efficient, but I say that my machines are not working and all. So today my capacity is 500. So will I be then classified as a less efficient unit? No. Your authorized license capacity is what needs to be taken into consideration.
Judgments.
ठीक है 4 है तो है हम नहीं बोले यहाँ আছে চিন্তা করছো
Judgments গুলো দিন
এই লিস্টে দেখুন তো
পেপার ওই পেপারটার ভিতরে আছে ওই কভারটার ভিতরে জাজমেন্ট গুলো
I had made my submissions from 4661. Your lordship had made all the markings.
4661.
Yes, 4661.
Give me the copy of judgments.
Well, it's a part of the pleadings itself. In the reply, the judgments are annexed. Your lordship had recorded it from the page numbers. We have annexed it itself.
Give me 4661.
Your lordship will find the judgments in the affidavit in reply filed by us in 4661. All the judgments are there. Same. Khali 3 different year.
I will make my submission in 6 hours from between.
May I be of any assistance when if your lordship is looking for any particular?
Affidavit in reply.
Yes, my lord. The reply would be, there is a heading on the affidavit in reply on behalf of the petitioner above name. This is in 4661.
Okay, I have got.
Yes, my
I
lord.
have I'm just searching the judgments.
It is your lordship will find it. Lord, your lordship will find the first judgment in the reply affidavit is at page 12A. This is the judgment in Godavari Sugar Mills. Page 12A.
Page 12A.
Yes. Then, my lord, your lordship will find the division bench judgment. It ends at, your lordship will see it ends at, this is the division bench judgment. It ends at page 29. This is the judgment of 28th May 1981. I stand correct.
Yes. And next judgment, there is an order.
Then, my lord, based on these judgments, Calcutta High Court and the other high courts have delivered judgment based
35A.
Yes, my lord. 31 is, my lord, 35 is the 35A.
Based on Godavari.
Yeah, based on Godavari. And my lord, also kindly take page 40.
Mrs.
38
Godavari
and 40. So Godavari has been followed by our courts. And writ petitions have been disposed of based on the proposition and the principles laid down by Godavari, by the division bench of Delhi High Court in Godavari. And then your lordship will also find there's another judgment at page 42 of Delhi High Court, which once again follows, it's a division bench of Delhi High Court, that also follows Godavari.
Yes.
Yes, so these are my respectful submissions.
In fact, today in this matter, I appear for the first time. Actually, I have prepared myself in respect of writ petition, that is Vishnu Sugar Mills.
Yes.
Vishnu Sugar Mills, writ petition number 13574W of 1981. I would just make my submissions from this writ petition. I believe whatever have been submitted by my learned friend, all the writ petitions pertain to the same issue.
It does.
Identical issues.
Identical issue. Therefore, what I understand from the readings that the writ petitioners are aggrieved. I do not know. This is a very old writ petition of 1981. Yes. And I do not know whether the cause of action still survives or not. But since the writ petition is being pressed, I am just submitting before your lordship that the writ petitioners are aggrieved by the inclusion of the writ petitioners factory in Schedule 5 instead of Schedule 6. That is the cause of grievance.
Yes, only efficient unit or less efficient unit.
Yes. So
they are placed under the efficient unit.
Yes, this has been done subject to your lordship's appreciation. This has been done in view of the price determination order of the central government.
Yes.
Now, which would appear from page 62. If your lordship kindly sees, and the date is very important.
Page 62.
Page 62 of 13574.
Okay. আরেকটা writ petition আছে না? এটা দিন 13574.
13574.
রিকনস্ট্রাক্টেড হয়েছে। এখানে রাখুন। ফ্যানটা বন্ধ করুন।
Page 62. That is the price determination order. Has your lordship got it? Page 62. Now, the date is very important according to me, Lord. This is 10th November 1981.
10th November 1981 order.
Yes. Now, my lord, the judgments which have been referred by my learned friend in the affidavit in reply, those are earlier judgments. If your lordship, Godavari's judgment is of May 1981, and this order of price determination is of 10th November 1981. And other judgments have followed Godavari's judgment, Godavari Sugar Mill judgment. Now, my lord, this is dated 10th November 1981. After this price determination order, my lord, page 62 of Vishnu Sugar Mills.
Yes.
Now, my lord, it says, my lord, kindly see, in exercise of the powers conferred by subsection 3C of section 3 of the Essential Commodities Act 1955, the central government hereby makes the following order, namely, short title and commencement. This order may be called the Sugar Price Determination of 1981-82 Production Order 1981. It shall come into force at once. Price of sugar produced in 1981-82. Now, I just skip over. These have been detailed. Now, if your lordship kindly sees page 75 of the continuation of the price determination order, the name of the petitioner's factory appears at internal page 14, serial number 11. Kindly see, Lord, serial number 11. Vishnu Sugar Mills Limited, page 70, running page 75, and continuation page of the price determination order,
page 14.
Page 14. Serial number 11.
11.
11. Vishnu Sugar Mills.
Yes. Vishnu Sugar Mills Limited.
Yes. This has been incorporated or included in the 5th schedule, thereby giving rise to the cause of action to the petitioners. Why not in serial number 6, schedule 6? That is the cause of grievance. Now, the deliberation was made on the representation of the petitioners.
Yes.
Prior to this. Prior to this order was issued, that is 10th November 1981, on the basis of the representation of the petitioner, which is appearing at page 58. If your lordship sees, page 58 is there. Page 58, representation was made to the concerned authorities. The case has been made out by the petitioner in their representation dated 10th February 1981.
Yes.
Page 58. May I read this representation? What is the case which has been made out? Dear sir, we have to invite your kind attention to the submission made by us to you dated 17th January 1981 for restoring our Gopalganj factory in Schedule 6 of the levy price notification under the sugar price determination of 1980-81 Production Order 1980. A copy of the above submission is enclosed herewith for your ready reference. Further to the above submission dated 17 January 81, we have to bring the following facts for your kind and sympathetic consideration. The sugar factory of our company at Gopalganj was installed in the year 1932-33 and much earlier to 1/10/1955. We have mentioned in the submission made to you on 17 January 81 that we are permitted to expand capacity from so and so by Government India Ministry of so and so. Now, license number so and so, the Chief Director Sugar Banaspati White, later dated so and so 62, inter alia permitted addition of one 3-roller mill of size 2654 to achieve the expansion in our capacity of 1200 TCD. The above major addition of mill could not be made till this date, and the same milling plant since inception of plant is continuing without any addition whatsoever. On going through the form II for the year 1979-80 enclosed herewith, you will find that some replacement of balancing equipments have taken place along with some minor addition for modernization. These replacements modernization were made just for removing bottlenecks in achieving the license capacity. We, however, applied for expansion of present capacity, which was turned down by the Deputy Secretary Government of India in the year 1977 on the consideration that the performance of the plant was not satisfactory, the copy of which has already been submitted along with our submission dated 17 January 81.
Yes.
Now, the expert visits of National Sugar Industries, Kanpur, have taken place from time to time, abstract of which has already been submitted in our submission dated 17 January 81, in which it has been clearly mentioned that the expansion of capacity can be achieved only after addition of 1 3-roller mill. No addition in milling tandem has been made, as such expansion of capacity does not arise. It will be pertinent to note that we have not even been able to avail the increased license capacity of 1200 tons due to serious bottlenecks and handicaps, mainly at mill section, air compressors, sulfur furnaces, juice heaters, cane feeding arrangements, lower speed at cane preparatory equipment, centrifugals, etc. Even on rare occasions when the rate of crushing was higher than 1200 TCD, it was it was only due to better management performance. In this connection, you will kindly note that under your order dated so and so, our factory was rightly included in Schedule 6, but again, while your order dated 13 January 1981, our factory has been incorrectly deleted from the above schedule without giving us any opportunity to be heard. As per estimates available, our factory is likely to be closed for the season 80-81 by the middle of February 1981, and in event on the spot inspection is desired, may be carried out at any early date. In this connection, we have also sent you a telegram reading as under. Regarding our submission for inclusion in Schedule 6 of Sugar Price Determination Order 1980-81 production order, our crushing operation for 80-81 season expects to continue only till the middle of February 1981. In event on the spot inspection is desired, it may please be carried out before the closure. Thanking you, Vishnu Sugar Mills Limited. Now we await your immediate action in the matter. So this representation was made on 10th February 1981, and the price order determination order was issued. Price determination order was issued on 10th November 1981. So this appears that after due deliberation of the representation, this order has been issued. Now, in this order, the petitioner's factory has been included in Schedule 5 instead of Schedule 6. Earlier, the petitioner's factory was in Schedule 6. They would have got much better benefit from the products.
Schedule 5 is the efficient unit.
Yes. So,
and Schedule 6 is the less efficient unit.
Yes. So, various factories have been included in Schedule 5 and various factories have been included in Schedule 6. Now, this is after due deliberation, it has been done. Now, earlier, the petitioner's grievance is this, that earlier they were included in Schedule 6. Now, not that suddenly, all of a sudden, this has been done. They made the representation, they took part in the hearing process. Thereafter, the factory of the petitioner has been included in Schedule 5. Now, I do not find any infirmity in the price determination order, which also enclosed the schedule wherein the petitioner's company factory appears. Now, thing is this, not that Schedule 6 is also there in the price determination order, where the name of the petitioner's factory did not figure.
Did not appear.
Did not figure. So, my lord, this has been done as a policy matter of the central government, my lord, in exercise of the power, my lord, given to the authorities concerned under the Essential Commodities Act. Now, my lord, I do not, and the judgments, my lord, which have been referred to by my learned friend, my lord, those are, my lord, prior to the determination order. Because Godavari's judgment is of May 1981, and the price determination order is of November 1981. Therefore, taking into consideration all the aspects, this has been done. But I do not find any infirmity in the order, and now much water has flown in the Ganges. But long back, I was a student of class 8 at that point. When the writ petition was filed, I just calculated, I was a student of class 8. Now, this is 25, and the writ petition was filed. I do not know how the writ petition still survives without being dismissed for default or something like that, as an old matter. In any case, since the writ petition is being pressed, I have to say something. But now, other orders have come out certainly, because by passage of time, this order, possibly, I do not have such instruction, possibly has been superseded by subsequent orders. I do not know whether the capacity of the mill of the petitioner has increased. It is supposed to increase by now. I do not know. I do not have any idea, because this is such an old matter. From the pleadings of the petition, I do not find any infirmity.
Only they have challenged the decision of the order. Only the point is that their crushing capacity is not under the efficient unit.
Right.
Less 1200.
Yes, because they have admitted. That's why I have shown to your lordship the representation made by them.
Yes.
They have said that
But why you place them in efficient unit? They have not such efficiency. You have not given license to such efficiency.
No, but your lordship has seen, Lord, why they are interested to go in Schedule 6. That is the test, subject to your lordship's kind of why they are interested. Because if they are included in Schedule 6, they would be much more benefited.
Yes.
They would be much
more levy in the.
But after due deliberation, the concerned authority has taken a decision that they should remain in Schedule 5.
Why? Why they have not given the capacity? They have not given the license of crushing capacity. Why they place the?
But considering their representation, Lord, kindly see the.
I understand. Considering their representation, the authority concerned has placed this sugar mill as efficient unit under Schedule 5.
Right.
But Schedule 5, regarding the efficient unit, they must have a crushing capacity beyond 1200. Beyond 1200 per day. Otherwise, they cannot come under the zone as efficient unit.
No, Lord, they have said
denied their.
No, Lord, they have said that it's likely to increase. Possibly that was the criteria.
That's why, whether there is an inspection that they have increased, whether their capacity to, they have applied for so that your their capacity may be increased by giving license. You have not given license and you place them in efficient unit. This is the question before the writ court only.
No, license is there. If your lordship kindly, license is there. Not
yes,
that
license there for crushing capacity up to 800 to 1200.
But kindly come to page 49, Lord. Because this is, Lord, I think, Lord, this is very relevant. Page 49. Liberalization of licensing policy. This is also a policy of the government. If your lordship sees, the licensing policy was liberalized.
The press release of 25% maybe increase like that.
Yes. That is the reason, Lord, as I find from the pleadings, Lord. That is the reason.
Whether they have increased their capacity?
Lord, if your lordship sees, Lord, page 51, Lord, the Vishnu Sugar Mills crushing capacity is there. Rate of crushing up to 80. Up to 80 crushing capacity is also mentioned.
Crushing capacity tons
Yes,
per day.
ton per day. 1031
999 per ton per day.
Yes. In the year 1980.
Not more than, never more than 1200.
No. It was not more than, but if 3 rollers were available, which were likely according to them, which were likely, then the capacity would have increased. So after considering that aspect, as I find, the price determination order was issued in 81. Now, because liberalization policy is also there. So I don't think that this is very material defect in coming to the conclusion that price determination order was issued in 81 and that should be vitiated. I don't think, subject to your lordship's kind appreciation. This is not fatal or not, this is not material at all. And if your lordship kindly sees kindly sees page 55. This is very important. Page 55. This is major recommendations of the high level committee. Not everything was taken into consideration. The recommendations of the high level committee was also taken note of. I am reproducing hereunder for your information question number 46 and the answer given by the Ministry of Agriculture
in Lok Sabha.
In the Lok Sabha on the 17th November 1980 regarding the above. Question: whether government have received the report on sugar prices from committee appointed for the purposes headed by the chairman of the Bureau of Industrial Costs and Prices. Answer: yes. Yes, sir. What are the major recommendations of the committee? The major recommendations made by the committee are indicated below. So the recommendations of the committee, high level committee, are also there, but taking into everything, all aspects. Well, the order, the price determination order was issued. Kindly have a look. These were dated prior to the issuance of the price determination order. So I don't find any irregularity or impropriety in the price determination order and placing the petitioner's factory in Schedule 5. But if your lordship kindly sees the recommendations, major recommendations, this would definitely but kindly see paragraph E at page 56. Possibly this would give the answer, Lord.
Yes.
I just read out for better understanding of all of us. There should be a 2-tier levy prices in each zone, that is one for the efficient, average and above average, and the other for less efficient units. The two criteria for determining the less efficient units are capacity being less than 1250 tons of cane crush per day and B, age of the plant over 25 years.
Yes.
So these were the major recommendations. Accordingly, things have been done.
Yes, though these two materials, these two criteria,
yes,
that is capacity being less than 1250 tons per day, crushing capacity.
Yes.
The petitioner says their mill is crushing capacity license for crushing capacity less than 1200.
That's correct.
Tons per day, and their plant is more than 30 years old.
Right, but that is of 1980. The statement made by the petitioner of 1980 and the price determination order was issued at the end of the year 1981.
So what is the determination? Determination is that the less efficient unit would be the capacity being less than 1250 tons per
Right.
day. That is the crushing capacity.
Right.
And
Age of the plant
it
over
would be
25.
25 years old.
Yes. Yes.
So Vishnu Sugar Mill says they have the crushing capacity, license
Less than
capacity less than
1200. Right.
tons per day.
Right.
And they are more than 30 years old. So they are come under the zone of consideration for less efficient unit. This is their plea altogether.
No, Lord, as I find, Lord, as your Lordship has seen, that is their contention. That is their contention. That's correct. But Lord, the representation, Lord, says something else that is likely to increase. And Lord, these two criterions, kindly see, less than 1250 and more than 25 years.
Yes.
The petitioner satisfy these two conditions.
Yes.
Your Lordship, I just understand what has fallen from your
Now,
Lordship.
what is your defense? Defense of the Union of
yes.
India is that as you have applied before the Union of India,
right,
for enhancing your crushing capacity,
right,
from 1200 to 2000,
right,
2500 like that, 2500 tons per day.
Right.
Though their representation or prayer was not considered, but the Union of India has considered that as you have applied for the same, that means you have the capacity.
But in fact, not considering the liberalization policy of the license, considering the liberalization policy.
And they have placed the judgments on the point that the policy about that is the levy sugar policy, price
Right.
policy has to be considered about the license on which the plant is granted. This plant, the sugar plant, was granted license of 800
right.
to 1200 tons per day
Right.
regarding crushing capacity.
Right.
This is only license,
Right.
not more license was given to them.
Right. Now, Lord, if your Lordship sees the liberalization of licensing policy, that is of 1969.
25% business you can be increased.
Yes.
You can increase
Yes.
25%.
So taking into consideration
whether they have increased the business on favoring that policy,
But on the basis of
whether
the,
there is such anything.
only 3 rollers would suffice according to the petitioner.
Whether
Accordingly,
those rollers are installed there, is there any report of the authority that they have already installed? They have the crushing capacity. They have enhanced their crushing capacity by
find,
virtue of the press notes.
yes, I understand, Lord. I find, Lord, the representation of the petitioner is dated, as your Lordship has seen. It is dated, Lord, page 58. Kindly see page 58. This is dated, right, 10th February 1981. And the price determination order was issued on 10th November 81. So, Lord, 9 months. Lord, possibly, I do not have specific instruction to that. Possibly when spot inspection was there. Otherwise, why they were placed in Schedule 5?
That's why I'm asking whether there is anything.
Yes. So this much, Lord, I can clarify, Lord, not if your Lordship, Lord, feels much more queries, then Lord, I will ask my junior to take further instructions and come back.
Only 2 questions, that is whether
spot inspection was
till today,
Yes.
till today, this matter revives or any cause of action is there in respect of this. Whether till
Well, the
today,
interim orders are subsisting.
okay,
The
interim order is
money that I have received based on the interim order, so I have received from the government of India as a less efficient unit.
Okay.
So the balance of between less efficient and efficient unit,
You are
that I have
depositing.
deposited in court.
Okay, okay.
So
You are
I am
regularly depositing in the court.
absolutely, and I am renewing the bank guarantee from time to time.
Okay.
In a separate bank account, it is kept. Now, my lord, if I may just take 5 minutes of your lordship's time, I'll just answer my learned friend. Your lordship will see the entire, my lord, the challenge in the writ petition is based on the decision-making process of the government of India. Why did you place me in the efficient unit as a efficient unit when in fact I am a less efficient unit? So, my lord, that action is arbitrary. So, my lord, there is no response by the government to my representations, which is at page 50, 52, 58,
Yes.
number one. So, my lord, in that representation, my lord, categorically we have made two statements that my production capacity is below 1250 metric ton. I have also stated that I had applied and you have rejected my application to give an enhanced capacity, and I have also given reasons. So, beloved, the undisputed fact when we filed the writ petition and when I was classified as a efficient unit, the fact remained, it's an undisputed fact on record today, that my capacity was still 1200, 800 to 1200. That was what was allowed to be enhanced.
That is
So
the license.
that is the
Granted.
license capacity. Now, my lord, if that is my license capacity and the press note given by the Minister of Agriculture, which is there, my lord, if your lordship will just see, with my learned friend just referred to, if your lordship will take at page 55, at page 56,
Yes.
clause E, that is exactly what it says. How do you classify a unit? So there has to be a parameter. There has to be some criteria. Criteria has been laid down by the government itself. So you have to follow the criteria while categorizing me in less efficient or efficient unit. Now, I say that I qualify based on my age and crushing capacity as a less efficient unit. You say no. Now, you have to justify why did you place me. That is the challenge in the writ petition. And that is exactly what Godavari judgment said. And my lord, the Godavari judgment is our particular year. Now, the proposition of Godavari judgment will apply to all years, whether it is 81, 82, 83, 84, regardless. So, because the policy of the government for placing the units, sugar factories in different category did not change. So, that policy of the government
Was not actually challenged.
no, my lord, the policy was never challenged.
Policy
The categorization was challenged.
Categorization, placing the petitioner in
Absolutely,
the
absolutely. Because we
efficient
say,
the challenge.
because we say that the categorization has been based on, my lord, it is whimsical, it is arbitrary, without reasons and without following your own policy.
Yes.
That's the whole challenge. So you ought to have followed your own policy while categorizing me.
Very well, I understand.
But this is the limited purpose.
But only one, I believe that opposition in this writ petition has been filed.
Yes.
Oppositions are there.
Yes. Therefore, in the opposition, I have a soft copy, I don't have the hard copy. So I believe that these points have been clarified in the opposition. But if not, I shall come back with further instruction, whatever has fallen from your lordship. I shall ask my junior to take written instruction from my client and come back.
No, you can, both of you can file the written notes of argument within 2 weeks.
Very well. We'll file it within 2 weeks.
I'm making the conclusion, concluding the argument.
All
okay.
But can it be 3 weeks, because we have to take instructions, written instruction from Delhi.
Because with respect, my lord, written instruction cannot be form a part of the argument.
No.
Well, notes of argument is what we've argued before your lordship.
That's correct. But
well, today, if the department gives some instruction or my client gives some instruction, that cannot form a part of the notes of argument. Whatever we have argued before your lordship, that we will put it in the note.
That is definitely within the compass of the pleadings. But we have to get the things clarified from my client so that we can place the proper written notes of argument.
Well, that clarification ought to have been taken before making the submissions. Well, today there's no scope of any further clarification.
For our better understanding, not that for placing it on record.
Come on, 19th of March.
Very well.
Argument
For filing of notes. Very
argument on behalf of the parties conclude. Let the matter fixed on No, parties are at leave to file written notes of argument within 3 weeks. Let the matter placed under the heading of 2 mentioned for filing written notes of argument by the parties on 19th of March.
At 2 p.m.
Under the heading 2 mentioned, it will be appear fast.
Very great. First half.
First.
Great. May I take your
Milord, just one submission, Milord. The opposition to 13574 of 1981, if a copy can be shared with us, because we have not been able to trace it from our records. And that is why we had argued it from the other writ petition in which all the affidavits had been completed.
All the oppositions are same.
Yes, Milord, if we just get a copy of that, because your lordship is keeping it on 19th, you also don't have it. I shall ask.
The writ petition number 13574 was reconstructed.
Yes.
I do not find anything regarding the opposition.
Yes.
Like oppositions is there in the
Other writ petition.
Well, same.
Absolutely.
Similar.
Same,
It would be same.
Issue are same.
Yes. Issue.
So why 3 writ petitions?
Milord, this is for four writ petitions are in your lordship's list today, Milord. Therefore, 4 separate years. The price determination
Price determination
orders
order is separate.
Separate.
Very.
4 lit. Milord, would your lordship be pleased to direct exchange of the notes of arguments prior to 19th, Milord? Would it be your lordship's?
I shall not allow anybody to argue further.
Milord,
That's why no reason to
deeply
exchange the
obliged.
notes.
Deeply.
May I please, your lord, that in this matter I am for the petition. I am for the private petition.
Who is for the state? You are for the state. Petitioner?
I am for the petition.
You are for the petition. What is the matter?
Well, that matter relating to distribution of midday meal.
Distribution of midday meal.
Distribution of midday meal to the government institution.
Whether it is under essential commodities.
Actually, it was controlled by the district magistrate.
Then how can it become under the Essential Commodities Act?
Actually, not under the. It is actually midday
It
meal.
is not
scheme.
under the Essential Commodities
It is a
Act.
scheme of the central government. I have stated in my paragraph, my lord. Kindly come to paragraph 5 of my petition.
Who has the determination in this matter? This is the order of the district magistrate.
District magistrate. Paragraph 5, my lord. Lordships, in the first order, my lord, page 26/7/2023, my lord.
Page?
First order, my lord, 26th July 2023.
Page?
Order sheet. Not in my petition, my lord. Order.
No, you have placed on license.
No, my lord. Not license, my lord. Petitioner is a scheme based on a scheme. Scheme, my lord. Paragraph 5, my lord. Paragraph 5 of my petition.
In page 21?
Page 21, my lord. My lord, petitioner is a petition number 1. Is a distributor of essential commodity. Distributor of essential commodity. That is another thing. And my lord, 2021, my lord, the district magistrate engaged the petitioner as carrying come distribution agent of midday meal, my lord. Page, my lord, kindly come to page 25. First engagement. Page 25.
How can it come under the Essential Commodities Act? This is the order of the district magistrate.
District magistrate. Subject, my lord. Page 25, my lord. Got it, my lord. Page 25.
Page 25.
Page 25, my lord. My lord, subject, my lord. Engagement as carrying cum distribution agent of for midday meal, MDM, for food grain. This is to inform that Messrs. D.N. Ghosh and Sons is hereby engaged to act as carrying cum distribution agent for
Midday meal section, office of the district magistrate collector.
My lord,
Murshidabad.
it is a central government scheme, my lord.
My only question is whether this issue comes.
Actually, not under essential commodities. Then not under essential commodities.
Let it be released.
My lord.
How can it hear it out? Order would be without jurisdiction. That's why I asked, why would not raise the issue?
Last 5-6 month matter is appearing before your lordship. None were raised that issue.
Which court has the jurisdiction? You approach before competent jurisdiction. Otherwise, this order would be infractuous and without jurisdiction. Your purpose would not be served. Hmm. I am releasing this matter. Please take down. Having heard the learned counsels for the petitioner, it appears that this court has no jurisdiction to entertain the writ petitioner, as the relief paid for not within the scope of Essential Commodities Act or any order connected thereto. Let the matter be released from the list. Petitioner is at leave to approach the appropriate bench having determination. Mr. Sahar, do I have the determination?
Convention in this sense because this is controlled by the Food and Supply Department. Entire scheme is controlled by the Food and Supply.
Maybe Food and Supply Department, maybe. But whether within
this question I have raised before Honorable Justice Chaudhary and
department may do anything, but this court
is kindly formulated by the POSHA, that is the Education Department of the central government. And thereafter, that was vested to the district magistrate. District magistrate is the appointing authority on the basis of the recommendation of the subdivision controller, food and supplies, and the district controller. That is the route
to video, my lord. District magistrate assigned the power to the video.
Whatever may be. But whether any order passed in pursuance to the
controlled by the
section 3 of Essential Commodities
just like a LPG matter. LPG matter sometimes filed in the residuary section and also essential commodities.
And in the petition, my lord, I am challenging the order passed by the district magistrate, not the district controller.
Then as per your submission, this is not
not the forum to
within this forum.
Desired relief cannot be passed by this court. If I pass any order, it will be without jurisdiction. He shall challenge the order, your order. He is ready to challenge your order on the point of jurisdiction. I know. Okay, it is released.
My lord, grant me liberty to correct the my lord, group, my lord. Correct the group of the.
You place it?
Place it before
the. You place it before the court, appropriate bench, by citing the order of this court. and correct there. No issue. Next matter.
Item number 5, I am appearing on behalf of the petitioner. Mr. Orkodipto Sengupta is appearing on behalf of the private respondent. I have been intimated by him that his mother is ill. For this reason, he has left to the court, Your Lordship.
Very.
Kindly make it not this week.
Not this week.
Great. Moreover, my lord, perhaps your lordship's order has been carried in appeal, my lord.
What order?
The order challenging the maintainability, they challenge the maintainability. That order has been carried in appeal.
That's a different issue. But
My lord,
copy has
I come to learn that order appeal has been filed, so I indicate it.
officially or unofficially?
Officially. Notice has been served, no memo or stay application has
Then-
been served.
Okay, then they preferred appeal.
Yes, they have prepared.
They should
Nothing
have.
has been served upon us, Your Lordship.
I understand.
But
Very well.
he has intimated that
Not
his
this week.
mother is
Not
ill.
this. Great, your lordship.
Call the list.
I am for the petitioner. Hey, I'm for the- I just put it there. But page 23 is the vacancy declaring notice dated 27th of December 2022, page 23. Lordship, kindly see the location of the vacancy in the table. Only 1 point second left hand side, second Moja and JL number. Have your Lordship got page 23. This is a notification of 27th of December 2022. Box left hand side, second serial, Moja and JL number.
Page 20.
23. That is not the legible copies. I have
Okay,
added
okay.
page 23. This is a notification of 27th December 2022. The box left hand side, second column, Moja and JL number. Muradiki 121. Have you also got my lord? The second I
121.
mark. Next to your lordship state, kindly come to page 43. I have applied for all documents I have annexed. Inquiry has been conducted. Then district level software action committee called me. All documents I have annexed. Need not go through the same. I made an RTI application. What is the present status of the selection? State to your lordship, kindly come to page 43. Query number 5. No one of the candidates have been finally recommended for granting license against the said vacancy to answer. As query number 6, none of the 14 candidates have been recommended. The said vacancy is expected to be notified.
Yes.
But I have made out a case in paragraph, my lord, 19 at page, my lord, 9. Page 9. I'm reading, my lord, at page 9.
Yes.
Your petitioner states that your petitioner came to learn from reliable source that the candidature of your petitioner has not been recommended. Since the shopcom godown of your petitioner is not situated under the same Moja, rather, my lord, the jail number as mentioned in the vacancy notification. Your petitioner states that the vacancy has been declared notified at village Muradiki near Muradiki, Kampajat so-and-so, block so-and-so, and Moja jail number Muradiki 121.
Yes.
Under Baharampur subdivision in the district of Murshidabad. And the shopcom godown of your petitioner is situated at village Muradiki, same place. Only kindly come to my lord, Moja and jail number Muradiki 118. That's the difference. In this regard, the petitioner mentioned that on introduction of the doorstep delivery, I have stated there is no need to learn that affidavit has also been handed over. But after making this submission on last occasion, it has been fallen from your lordship that if there is a specific condition, if I fail to fulfill the same, others have not yet applied for. They are also land, they have the shop room, but in separate Moja. Although I am saying, my lord, this is a 20-foot distance. I understood, my lord, your lordship's observation is correct. I cannot say, whatever may be the condition, unless I fulfill the same, they have the right to reject my application. So today I am only praying, my lord, my application may be treated as representation, director may be considered. I'm not pressing for any interim order or something else. I have stated, my lord, and affidavit I have also been handed over on last occasion. If you want to kindly see the report in the form of affidavit. On last occasion, I have handed over that the same self-subdivisional controller.
Yes,
This has been stated. But this is in connection with MAT number so and so. MAT 1503. A report filed in connection with MAT 1503. I have handed over the copy where the same subdivisional controller says that location is not a factor today because after introduction of the doorstep delivery, it is the duty of the dealer to deliver the goods to the doorstep of the consumers. Well, this is a report submitted in connection with MAT number 1503 of 2024. Your Lordship has gone through the same on last occasion.
1503 of
My Lord,
2012.
kindly only one paragraph, my Lord, paragraph number 4X at page, my Lord, 6. The same subdivisional control, Barampur Sadar. But I am not pressing, my Lord, since it has been rightly fallen, I must say. Like this is one of the criteria. So, director and DDPS, maybe after recording my submission, it may be forwarded to the district director DDPS. I mean,
Take your breath first.
Aste.
Lordship, in the last occasion, Lordship, I have placed one judgment which it has been informed that they have approached the Apex Court. Lordship, there is no order of stay in regard to that judgment, Enterprise, Lordship, which I have cited in the last occasion, Lordship. Secondly, Lordship, this is an administrative decision, Lordship. Whether the petitioner's application should be considered or not, it is purely an administrative decision, Lordship. In a similar matter, wherein Mr. Shahara only argued, and he has taken the similar point that although the petitioners there, Mr. Shahara appeared. আপনি appear করেছেন। If Lordship kindly comes to page number 3 of this. Page number 3. Second paragraph, Lordship. The last sentence. Here, Mr. Shahara appeared for the petitioner. The main contention was that petitioner's godown of the petitioner was within that Mauja, and the private respondent's godown was outside the Mauja. So the main contention of Mr. Shahara was that, if Lordship kindly comes to the second last line of the second paragraph, on the contrary, he has his godown at village Shorisha within the police station Diamond Harbour, which is far away from the village Bhushna. Just the opposite contention, which Mr. Shahara argued here. And the third is that here I only have one copy of this Supreme Court judgment, Lordship.
I am disposing of the writ petition by directing the petitioner to before the concerned authority.
Director, my lord. I shall make a representation and they will
For the director to make a representation why such a answer was given by the authority.
My lord.
One says none of the candidates are underqualified, and one says it is under process.
And that is the latter date.
Sorry, pardon me, Lordship.
Page 43 and 44. দু রকম উত্তর দিচ্ছে। Retail.
Retail, page 43, 44.
None of the 14 candidates have recommended.
43 একরকম বলছে, 44 অন্যরকম।
Expected to be notified.
Yes, Lordship, what my instruction, Lordship, specifically says that there has been a direction, the recommending authority has said that re-notification is required. None of the 14 applicants are eligible.
I understand.
Page
So
44.
why the re-notification?
Page
Why
40.
the under process?
Page 44.
Because that recommendation of re-notification has not yet been considered. The direction from the authority is yet to come to the recommending authority, that whether re-notification is required or not, because we have not recommended a single applicant. And
Okay.
today, if petitioner is being given a chance, tomorrow every other applicant will come down and ask for justification, Lordship.
Very hard.
The director is the respondent number 3.
Please take down. Petitioner applied for FPS license in terms of vacancy notification number 138 dated 27th December 2022, issued by the Subdivisional Controller Food and Supply, Behrampur, Sodor. Petitioner filed the application, comma, his proposed shop cum godown was inspected, comma, he was called for in an interview by the concerned district fair price shop selection committee, but thereafter no decision was taken by the authority. However, he filed an application under Right to Information Act, wherein the Subdivision Controller Food and Supply has replied page 43, query to answer 4, 5 and 6. The answer was provided on 24th of September 2024. Thereafter, on 26th of September 2024, in terms of another query, the authority concerned has answered as follows. Query number 5 and 6. Query number 5 and 6. I don't go leave it. Query number 5, 8, query number 6, 8. Learned counsel appearing, Mr. Sahara, learned counsel appearing on behalf of the petitioner submits that the authority concerned has not taken note of the entire procedure, but had issued 2 answers which are contradictory to each other. He submits that he pleaded in the writ petition that the proposed shop cum godown of the petitioner is very near to the vacancy location, though it is falling within the same mauja, but it is within jail number 118. The concerned authority has not considered the same. However, no order of rejection has been passed. Learned counsel appearing on behalf of the state authority submits that none of the candidates were eligible. None of the candidates. Now, there are 14 candidates. None of them, there are 14 candidates. None of the candidates have been finally recommended for granting license in respect of the said vacancy of fair price shop. However, the issue was not finally decided and it was placed before the upper authority. Having heard the submissions of the learned counsel for the party, it appears to me that the authority concerned had to act upon the tender procedure and tender notice strictly. However, the decision of the authority was not properly intimated. Moreover, it raised confusion upon the petitioner, upon the mind of the petitioner regarding petitioner by issuing two types of answers. Under the observation, I think it necessary to relegate the matter before the learned Director, District Distribution and Procurement, Director, District Distribution and Procurement Supply, DDPS, being the respondent number 3, to take a reasoned decision on that point. Full stop. The petitioner is directed to approach the respondent number 3 with a proper representation within 2 weeks from the date of passing of this order. On such representation, the respondent number 3 shall dispose of the representation after giving an reasonable opportunity of being heard to the petitioner within 6 weeks. Decision of the authority shall be intimated to the petitioner within 2 weeks thereafter. Disposed of. Represent disposed of on the above observations. I make it clear that this court has not entered into the merit of this matter. This court has not entered into the merit of this matter. The concerned authority is to decide the matter according to the law. Full stop. As affidavits are not exchanged between the parties, the allegation made in the writ petition shall be deemed to have been not admitted according to the law.
Great.
In 21, your lordship may remember the rising of the time, Mr. Learned State Advocate.
Yes.
Roger Datta paid for time to file their affidavit. I am for the petitioner in this one.
Not this week.
No, they paid for time to extend the time to file the affidavit.
There are interim order, I think.
Interim order in the meantime, so there is no need to extension.
Okay. Okay.
So make it 2 weeks. Okay. They paid for 2 weeks, but I'm.
Let the matter appear in the list on 10th of March.
The 22, I appear for the writ petitioner. My lord, at last, pursuant to your lordship's directions and our repeated endeavor, we have been able to serve the private respondents. My lord, here is their affidavit of service to that effect. My lord, the writ petitioner has challenged. When the writ petition was filed, the recommendation was made in the name of the private respondent about the license, and such was challenged. And during the pendency of this writ petition, as per my learned senior friends' submissions, that they have been, the private respondent has been accorded with the license. But we have challenged the writ petitions on twofold grounds. Before coming to that grounds, my lord, on the last occasion when the matter was heard, my learned senior friend of the state authorities had filed one-page filed the result sheet, which was not handed over, but they were kind enough to take us a photograph of that. My lord, taking into consideration the result sheet, my lord, it is absolutely palpably erroneous, the markings that they have put in just to, my lord, cater the needs and whims of the private respondents. I can show from your lordship, from the records itself and the report that they have, my lord, filed before your lordships, although there is no report in the form of an affidavit to that effect. So, my lord, may I submit on threefold counts. First, initially there was an inspection held. Initially there was an inspection held on the 9th of May. The petitioner's premises was also inspected, as well as the private respondents. Thereafter, on the plea of the petitioner that the inspection was not conducted as per the norms and procedures, a further inspection was also held on the 3rd of August, 2024. First, it was 9th of May, 2024, and thereafter it was 3rd of August, 2024. And during this inspection, my lord, the private respondents whose inspection was, I don't think that anybody, I have not made any allegations that private respondents' inspections, premises should be re-inspected or revisited. But unfortunately, or fortunately unfortunately for us and fortunately for him, the private respondent's premises was also re-inspected or revisited. And it was found that his premises was in a better footing, although from the my lord, categoric submissions made by my learned senior friends in the result sheet that has been published, I can demonstrate before your lordships that till such time the inspection was held on the 3rd of August, my report was, my status of being fulfilling all conditions was not considered. My lord, kindly takes, if your lordships have that result sheet with your lordship. And I have prepared a comparative, not a chart, since it was not filed by way of an affidavit. I could not have prepared anything, my lord. The result sheet suggests that, my lord, 3rd is Mumtaz Hussain, the petitioner before your lordships. And 2nd from the last is Rajesh Kundu. My lord, the petitioner belongs from that particular Gram Panchayat. Kindly compares. May I take your lordships to the first category? That is size of the godown. Both of them have been given same marks. I say that I have also pleaded in my affidavit that his godown was not prepared on the date of the inspection. Second, the size of the attached shop. The report filed, my lord, the 3rd of August, I have appended their report in the writ petition, suggests that my premises were there. My shop room is absolutely, my lord, adjacent to my godown. I have been given 0. My lord, I fail to understand. Nature of possession, third category. My lord, I was given the same marks. Building type, shop and godown. My lord, I was not given any marks. Thereafter, 10-ton trucks unloading. My lord, I was given 5, and he was also given 5. It is an admitted position that his godown was not prepared, and the road that, my lord, since we belong from a same locality, the road that is approachable to his godown cannot, at this very moment, cannot attract this 10-ton truck. On oath I have submitted, my lord. Let them file an affidavit Disclosing all these, my lord, this result sheet, I shall deal with that affidavit, my lord, in my exception. Thereafter, my lord, the domicile, kindly sees. I have given 5. I have been given 5. But I should have been given 10 out of 10 because I am the resident of that Gram Panchayat. My lord, I am OBC category. Yes, I have been given 3 marks for that. My lord, my account, which ought to have been 63, I have been given 58, and which comes around to 74 in total. And he, although he has been given 73, just a marks, but that marks also should not have been given pursuant to his nature of go down and his, my lord, his stage of the go down when the inspection was held. But I will humbly beseeching your lordship, my lord, before your lordship takes any further this writ petition, kindly directs the respondent authorities to file a report disclosing 2, my lord, inspections reports, 2 dates, and the result sheet. It will be clear before your lordship that whether the private respondent had that eligibility to have this license or not. And I, being the, my lord, candidate who should have been given the license, it is not the case that nobody was given. He was favored with this. And in spite of service, my lord,
you scored 58.
Yes, as per their record, I scored 58, which totals amount to 69, and he was given 73. I will show from my records, my lord, that I should have got 74 marks in total.
And
he even if I take this, although I dispute this 73, even if I, for the argument's sake, I take this as a sacrosanct truth, then also my scores develops over him. I scored 74.
Yes.
Well, your lordship
It cannot be decided right now.
Yes.
It cannot be decided. Lordship considers the order that was passed by lordship on the last occasion. My submission was recorded that I handed up the score sheet.
Yes.
The same which I was referring to, my lord.
And then, my lord, I showed that he scored less than the respondent who has been given the license already.
Yes.
And respondent number 6 is running it. So now it has become more or less academic.
I don't think so, my lord. I submit to differ, my lord. Sorry.
Now that now what happened, my lord, your lordship possibly cannot delve into the domain of the administrative authority. How they judged and how they awarded marks, how the score sheet was prepared, that possibly may not be gone into by the read court. Now it is up to your lordship, but kindly, my lord, records that service private respondent was required to be served again because there was
But I have served, my lord. It's affidavit was served.
Very good. Now, my lord, if your lordship directs, I can file a report.
You file a report in the form of affidavit.
Or an affidavit.
Yes.
A report in the form of an affidavit will do, my lord.
The report would be sufficient.
Well, then let me affidavit in opposition.
Affidavit in opposition. Very
better.
3 weeks.
The report is
3 weeks.
3 weeks. 4 weeks. 4 weeks.
4 weeks. Very well. Affidavit of service file on behalf of the petitioner is taken on record. It appears, after hearing the parties, it appears that the writ petition cannot be disposed of without giving an opportunity to the state respondent to file an affidavit in opposition. Let the affidavit in opposition be filed within 4 weeks from date. Exception: reply against the affidavit be filed by the petitioner within 2 weeks thereafter. Let the matter go out of the list. Parties are liberty to petition.
Only records my submission that respondent number 6, after being given license, is running the shop at present. Let that be recorded.
Yes, my lord. And to that effect, my lord, I was humbly praying before your lordship that any steps taken shall abide by the result of this writ petition. This much of any step. Yes, yes. That all steps taken, my lord, I shall show from. I have filed this writ petition before. No, my lord, kindly. My lord,
No interim order.
I am not seeking for any interim order. I was just praying that any step which has been taken shall abide by the result of this writ petition.
I have
Otherwise, my lord, this writ
I have
petition will be
admitted the
redundant, my lord.
petition. I have admitted the writ petition
Yes,
right.
yes.
Because the result is there.
Yes, my lord.
Result is
Hence, my lord, I was, my lord, for my lord, kindly, my lord. Otherwise, my lord,
That is farce, sir.
my lord,
That will be order will be farce. I
my
shall
lord,
not parse any first order. If you succeed, I will terminate the license. That is the issue.
my lord.
So,
My lord, then kindly, my lord, then kindly on my personal satisfaction, let a date be fixed for hearing, my lord. Kindly not let the matter be go out of list.
let the AO is submitted.
My lord, if in that event, my lord, I was just humbly requesting your lordship, my lord,
Mention
after the expiry of the time, may I let
Yes,
it
you
be
can mention.
listed, my lord.
Parties are at liberty to mention.
My lord,
Parties are at liberty to mention after completion of the exercise.
my lord, if they choose not to, my lord, file their affidavit, then also, my lord.
Don't preempt anything.
My lord, since my lord,
Always go fast.
Today we cannot presume like that.
yes, but
I have
also,
directed, and I think the authorities shall consider the direction and shall abide by the direction.
yes,
In its true perspective.
we all think like that, my lord.
Yes.
Grateful, my lord.
Next.
23, my lord, I am for the petition, my lord. Well, last occasion, my lord, state is directed to file, my lord, report in the form of affidavit. 27 January, my lord. No. State is, my lord, directed to file a report in the form of affidavit, my lord.
Your lordship,
27 January, my lord, your lordship pass an order.
I'm praying for 1 week's accommodation, your lordship.
And Mr. Dhara, you also file affidavit in opposition? Ready?
Well, last occasion he is not appearing. My lord, I have served the copy. Affidavit service file.
Very well. He
Today
is
he is,
appealing
my lord,
today.
yes.
So 1 week required.
1 week accommodation, your lordship.
Mr. Dhara, within 1 week you can you? 2 weeks. Okay. Learned Counsel appearing on behalf of the state authority submits seeks accommodation for extension of time to filing a report in the form of affidavit. Full stop. Next para. Private respondent represented by Mr. Dhara submits that the private respondent shall use affidavit in opposition against the writ petition. Let the affidavit in opposition by the private respondent and the report in the form of affidavit of the writ petition be filed within 17th of March 2025. Reply, if any, by the petitioner within 24th of March 2025. Let the matter appear in the list on 25th of March.
Yes.
Under the same heading. Next. Again 1 week.
Only 1 week.
You are appearing for the state authority.
I am for the petitioner.
Learned Counsel appearing on behalf of the state authority seeks accommodation for extension of time to file a report in the form of affidavit. Let the report be filed within 10th of March. Reply, if any, be filed within 17th of March. Let the matter appear in the list on 18th of March. Under the same heading.
On the next day, if they don't file, then I shall pay for an injunction. On the next day, at least. No, I am for the petitioner. This is an affidavit of service. But this is a case relating to kerosene oil agent. Your Lordship, kindly turn to page 18 of my writ petition. This license granted by the Food and Supplies Department for running my kerosene oil agency. Kindly see, my lord, like address, name, KL Gupta and Company, then my lord, is hereby licensed to carry on business as an agent in kerosene from his depot at 6 Radhapallapuram, Mitroganj Bazar. Then my lord, operational area, Joynagar and Kultuli block. Have your lordship got, my lord? Joynagar and Kultuli block. Well, your lordship knows, so far kerosene oil is concerned,
So
agreement.
you are licensed to carry
Yes,
on the business as an agent
my lord.
in kerosene from depot to Joynagar and Kultul block.
My lord, this is the my operational area. Your lordship knows, my lord, kerosene control order suggests that the agreement should be executed with the respective oil companies, that is either IOCL, BPCL, or HPCL. On the basis of the agreement, I shall run the business, but the allocation shall be made by the state authorities. As per the requirement of the location, this will be forwarded to the particular oil company, then oil company will deliver the same. And in this regard, an agreement is being executed by and between the oil company and the agent. Not like the distributors or dealers, there is an agreement executed by and between the oil companies and the agent. After getting the agreement, I shall approach before the licensing authority. They will issue a license for running my business. Now, your lordship, kindly, well, may I show the provisions, my lord? Just one provision. If your lordship, kindly take the book, page 3.5. After urban control order, page 3.5, bottom. After urban control order. No. 3.5 page, bottom portion marking is there.
I cannot.
I am handing over. I have two books, my lord, not read that.
3.5.
My lord, first, your lordship, kindly 3.5.
West Bengal kerosene control order.
Have a lordship got, my lord? It starts from page 3.3 or 3.1 after urban control order. You may take up my books, my lord. Only two provisions I shall place before your lordship. Yes. 3.5.
Urban public distribution.
After expiry of urban control.
No.
That runs up to, my lord, 2.113, then 3.1. Urban control order expired on 2.116 page, top. Then bottom 3.1.
2.116.
Yes, the last page of the urban control order. Annexures. Then it starts from 3.1. It has been marked in the bottom.
Kerosene control order.
My, your lordship, kindly take up 3.5. But definition clause 3.b at page 3.5. Definition clause 3b.
Agent.
Agent means a person who executed an agreement with the concerned oil marketing company and has been granted a license under clause 5 of the order as an agent in West Bengal, authorizing him to carry on trade in kerosene of such agent. Your lordship, kindly click 3O. Next page, 3O. Page 3.7. License, have a lordship got, madam? 3.4, page 3.7, middle portion.
License.
License means a SQL agent or an SQL dealer holding a valid license granted under this order. Then P.
Yes.
Licensing authority means the director of consumer goods in case of SKI agent. So far our case is concerned, throughout the state of West Bengal, and in case of SKI dealer within Kolkata and Bidhannagar areas, the district magistrate in case of SKI dealer within. So in districts, my lord, district under the jurisdiction, district magistrate is the authority. So far the dealer are concerned, and in respect of agent, director of consumer goods. Now your lordship kindly take up license para 5, page 3.8. Grant of license. Clause 5.
Yes.
The director of consumer goods with proper approval of the state government will communicate to the oil marketing company the area where requirement of engagement of an agent has arisen, clearly delineating a landmark defining so and so. So, the proposal shall be made by the director of consumer goods requesting the oil company to engage an agent. So, appointment, first appointment by the oil company, then dealership agentship license by the food and supplies department. Then, clause 1A, kindly read.
No, in case of agent.
Yes, director of consumer goods is the licensing authority.
Licensing authority.
Agreement should be executed by and between the
oil company and the agent.
The
agent.
Yes. As per proposal of the director of consumer. That will appear from paragraph 5.
Yes.
Then, my lord, 1A has been given, director of consumer goods shall on receipt of the document. So that is there, my lord. Your lordship need not go through all those provisions. As per requisition of the director of consumer goods, oil company shall deliver the goods to the respective agents. Now, your lordship kindly come to page 19 after my license. Page 19. One of the agent of the local died, and then his entire dealers have been tagged with me, which will appear from page 19, 22nd of May 2024. I am reading, my lord. Subject: proposal of tagging of SQL dealer attached to SQL agent Messrs. Abul Hasham Khan with Messrs. KL Gupta petitioner before lordship and the company under Muthurapur 1 block and Diamond Harbour subdivision and Joyanagar and Baripur subdivision. Madam, in connection with the addressing to the deputy director by the district controller, in connection with the subject mentioned above, the undersigned has received 2 tagging proposals from subdivisional controller Food and Supplies Diamond Harbour and subdivisional controller Food and Supplies Baripur for smooth running of public distribution system, which are as follows. Messrs. Abul Hassan Khan of Raideki under Muthurapur Swanso, KL Gupta Swanso, Shankar under Swanso, Messrs. Abdul Hakam Khan, Joyanagar Block Swanso with Mr. KL. But both have to be tagged with me. That's the proposal of the district controller. Because
above 2 are hereby recommended and forwarded to your end for taking necessary action.
My lord.
So 1 and 2.
1 and 2.
Abdul Hasem Khan of Raideki.
Both are Abdul Hassan Khan. Some fallen, my lord, one particular subdivision and another is another subdivision. So both the subdivisional controller recommended that these are the nearest agent. So all these dealers of Abul Hassan Khan shall be tagged with my agency.
Yes.
Now kindly turn the page, my lord. Page 21, straight away. Tagging proposal in respect of Abul Hassan Khan of oil agent. This is a letter of 22nd May 2024. With reference to the subject mentioned above,
reading page
21.
1. Okay.
Tagging proposal of respect of Abul Hassan Khan.
21 is otherwise.
It's not so legible, my lord. May I read, my lord? Page 21.
Yes, tagging.
With reference, yes. Then with reference to the subject mentioned above, it has come to the notice that Mr. Farooq Ahmed Khan, one of the partner of Mrs. Abul Hassan Khan, has submitted an application requesting termination of suspension of their agency. As the matter is still under process and it might take time under these circumstances for smooth running PTS Consular agency, Abul Hassan Khan may be tagged with KL Gupta, petitioner before lordship. This is why one of the subdivisional controller. Then kindly turn the page, my lord. It has been materialized, which will appear from page 22 at the dated, my lord, 28th of May 2024. Whereas Abul Hassan Khan, partner so-and-so, expired on so-and-so, whereas neither extension of temporary permission towards continuation of their business from non-professional agreement open consultation has been received from SQI agent. Therefore, in terms of para West Bengal Kerosene Control 1968, as amended, all the SQI dealers tagged with Mrs. Abul Hassan Khan Joynagar are hereby temporarily delinked and tagged with the nearby SQI agent of Mrs. K.L. Gupta Joynagar as per proposal of District Controller Food and Supply until further order. Mrs. K.L. Gupta Joynagar is directed to leave the closing balance of SQL presently lying with Mrs. Abul Hassan Khan Joynagar SQL agent and allocation for the month of May 2024 onwards and distribute the same through newly tagged dealers in accordance with the direction of the District Controller Food and Supply South 24 Pognas at prices approved by the competent authority and maintain a separate set to the books accounts so and so. Then name of the oil marketing company IOCL, the box Baruipur and subdivision and Joynagar block name, number of cards, number of digital RCs, total RC, closing balance, gross allocation, kindly turn to the right hand side, last column, gross allocation on tanker equipment, KL 108 KL. Have a look at 131. This is additional to my allotment. Temporary basis due to death of one of the partner of Abul Hassan Khan. This is temporary. Now, Your Lordship, kindly come to page 26. Allocation sheet I have also annexed, page 26, first column, LK Gupta, account Abul Hassan Khan. Have you Lordship got my lord? On account of Abul Hassan Khan, I am getting this since all the dealers are nearer to my agency. Everything is there. Then kindly come, my lord, page 29. Another month, this is kindly see top, August 2024 is there, middle portion, top, up to August, kindly see, same thing, LK Gupta. Then kindly come to my lord, one paragraph of my read petition at page 6.
No, this is for the August 2024.
Yes, up to August. There is no dispute.
August 2000.
And previous one is June. If you also kindly see, page 26 for the June. Now kindly come to my lord, two paragraph of my read petition at page 6. I am reading paragraph 10. It is pertinent to mention here that for the month of May, at page 6, paragraph 10.
Yes.
It is pertinent to mention here that for the month of May and June 2024, petitioners were allotted 108 KL and 144 KL on account of AH Khan, in addition to their usual quota of 84 KL, only on account of, say, defunct agent for Diamond Harbour point, but the quota for Baruipur, which earned KL, was allotted to another agent whose place of business does not include Baruipur availability. Both subdivision of food and supplies, Department of Food and Supplies recommended us for having quota meant for the deceased agent. It is also noteworthy that the H. Khan was distributed to KL at Joynagar and Pultuli block. Then, paragraph 11, that the petitioner states that dealers of Joynagar who were previously tagged with Abu Hashem Khan, as well as dealers of Pultuli who ought to have been tagged with the petitioners as per condition of license, have been tagged with an agent operation from Bakrahat, nearly 50 km away from Joynagar and almost 100 km away from Pultuli. But kindly, Your Lordship knows, whenever a person died, submitted resignation or license terminated, it is the usual practice that his ration cards or dealers, either MR distributor, MR dealer or traditional agent or traditional dealer, shall be tagged with the nearby agent or dealer. Following the same, both the subdivisional controller recommended, that has been accepted, allotment has been made up to August. Then, my lord, kindly turn to state where, my lord, page 30, which is the impugned. It's the allocation order of 9 December 2024. Serial number 4, Joynagar block. Kindly see, instead of SP Singh and brother account IS Khan, KL Gupta, United Oil Agency, and 5 Pultuli block, SP Singh and brother account AH Khan. Instead of me, it has been given to another agent whose agency is 50 km away from the dealer's point. I made a detailed representation. Your Lordship need not go through the same. Kindly turn to page 31. It's
So
dated-
some of the allotment of H. Khan was given to SP Singh.
Yes,
and
instead of
brothers.
me. Up to August to me, thereafter it has been tagged with other agent whose agency is 50 kilometers away from the dealer's point. I made a details representation. If you want to kindly turn to page 31. This is 18th of October 2024. After making this representation, I also make a further representation to the Director of Consumer Goods on 21st of January 2024 at page 33. So far, my first representation is concerned. Copy has been given to the subdivisional controller, district controller, which will appear from page 32. And the next representation copy was also given to the district controller, subdivisional controller, page 32. One of the dealers who have been dealing from me, temporarily tagged to me, also made a details representation to the subdivisional controller, being the licensing authority. Now the subdivisional controller once again requested the district controller to retag the same with me for the beneficial of the public. Kindly turn to page 35. This is a communication of 11th December 2024 addressing to the district controller written by the subdivisional controller, food and supply, Baruipur. Kindly read, my lord. Subject: enhancement of monthly allocation of SQL to Mrs. L.K. Gupta, company tagging dealer. I am inviting your kind attention to the subject matter referred to above, that taking necessary action in this regard. Mrs. K.L. Gupta, company, SQL agent of Joynagar, 1 and 2 block. After getting fresh license, they were allotted 04 KL SQL for Joynagar, 1 and 2 block under Baruipur subdivision. After the death of Abul Hasham Khan, proprietor of Messrs. Abul Hasham Khan, the said agency turned defunct, and Mrs. K.L. Gupta and company was allotted the quota of the defunct agent as it was nearest to their place of business. For the month of May and June 2024, Mrs. K.L. Gupta and company were allotted 108 KL and 144 KL respectively on account of Mrs. Abul Hasham Khan, since defunct, in addition to their usual quota. But from August 2024, all tagged dealers of Kultuli block from Mrs. K.L. Gupta and company and tagged with Mrs. SP Singh and Podar, an agent office at Fakrahat, which is more than 50 kilometers away from the Kultuli block. Kindly take note of. So all the 74 dealers of Mrs. Abul Hasham Khan, since defunct due to death of Abul Hasham Khan, are facing difficulties for traveling that long distance. As a result, the distributors of SQL is being distributed. But they made also representation. These dealers, we are facing troubles. Now the 74 dealers of Kultuli block want to tag with Mrs. K.L. Gupta and company having distribution points at Joynagar, since the said agency is nearer to their business place. In view of the above, undersigned would like to propose that 74 dealers of Kultuli block may be detached from SP Singh and further tagged with Mrs. K.L. Gupta and company for smooth running of the sales. But today I am not pressing for final decision of this matter. If you are to kindly direct the Director of Consumer Goods to consider my representation at page 31, taking note of the recommendation made by the subdivisional controller within a certain time. My representation at page 31 is dated 18th October 2024, and the recommendation made 35, dated 11th December 2024, made by the subdivisional controller, food and supplies, Baruipur. Let them take a decision, because my representation is still pending for consideration. And during this period, dealers have made a representation. Considering both the representation, subdivisional controller recommended, the district controller and district controller forwarded the same to the director. Now the issue is pending before the Director of Consumer Goods. These are my submissions.
Lordship, if I may. Lordship, I have the instructions given to me from the subdivisional controller Baruipur himself. If Lordship would just like to take a glance, then it will be easier for me to point out the paragraphs, Your Lordship. See, Lordship, the third paragraph. As per the order of the Directorate of Consumer Goods, V-Day such and such, dated such and such, all the dealers of MS Abul Hashim Khan has been temporarily tagged. And then the last two lines. As neither of temporary permission towards continuance of their business from OMC IOCL nor fresh agreement upon reconstitution has been received from the SKO agent. Then, Lordship, page 2, the next page, where the third paragraph from the top, where it says, rather he says, that it was found that both the SKO agents of MS KL Gupta Company and MS SP Singh and Brothers have storage point, which are equidistant from
You are reading?
page 2, third paragraph from the top.
As per order dated.
Yes,
Director
yes,
Consumer
Lordship.
Goods mentioned above.
Yes, Lordship.
Yes.
The second line, it was found that both the SKO agents of MS KL Gupta and Company and MS SP Singh and Brothers have storage point, which are equidistant from MS Abdul Hashim Khan Joynagar, the deceased dealer. But the RC position of MS KL Gupta and Company is significantly higher than that of SP Singh. Therefore, since he had higher ration card holders, for the convenience of the ration card holders, some were detagged and some were given tagged with another dealer. That is his major complaint, Lordship. And he is asking the subdivisional controller Baruipur to address. Subdivisional controller Baruipur himself has given this report, which is in front of you, Your Lordship.
No, he is asking for the
Consideration
taken by the Director of Consumer Goods.
Yes. No, I'm just pointing out the first part. That is the subdivisional controller's report. And then, since he dealt with para 10, here, Lordship, if Lordship may come to page 5, para 10 has been dealt with in detail.
Yes.
Yes, Lord. In the interest of PDS to supply SK oil to his tagged dealers as neither of temporary permission towards continuance of their business from OMC. Page 6. Para 10 continues into page 6, Lordship. Continuance of their business from OMC IOCL nor fresh agreement upon reconstitution has been received from the SKO agent. And therefore, they say that quotas were given, extra quotas were given, since it was tagged that way. Then, Lordship, it also mentions the order of the Directorate of Consumer Goods. Next paragraph.
Yes.
As per the order of the Directorate of Consumer Goods mentioned above, in connection with the petition, it was found that both the SKO agents of MS KL Gupta and Company and MS SP Singh and Brothers have storage point, which are equidistant from the MS Abdul Hashim. So even the Directorate of Consumer Goods is of the same opinion, Lordship. But the RC position of MS KL Gupta and Company is significantly higher than MS SP Singh and Brothers. Therefore, as per the order of the DCG, that is the Directorate of Consumer Goods, following the provisions as laid down in the West Bengal Kerosene Control Order of 1968 as amended, all the dealers tagged with MS KL Gupta and on account of MS Abdul Hashim Khan have been delinked and relinked temporarily with the nearby SKO agent MS SP Singh and Brothers for smooth running of PDS. And Lordship, the last page, there's an order dated 19/7/24. This is also not very clearly legible, Lordship. But this order deals with it clearly. And as Lordship would see, it is from the Director of Consumer Goods itself. Last page, 19/7/24, Has Lordship found that letter, Lordship? The order?
Yes.
It comes from the Government of West Bengal, Directorate of Consumer Goods.
Yes.
Now, in connection of the petition, it is found that both SKO agents of MLKL Gupta and MS SP Singh and brothers have storage points which are equidistant. He again reinstates this fact. But RC position of KL Gupta is significantly higher. Therefore, as per provisions laid down, so the submission made there, the annexure supports it.
Just one line reply, my lord.
Yes.
My lord, convenience and inconvenience of the dealers are the most consideration. Your lordship, kindly turn to page 35. The distance from the previous agent and agency of my client and Singh may be, my lord, equalized. Kindly see, my lord, page 35, last but one paragraph. Now the 74 dealers of Pultuli block want to tag them with Messrs. SKL Gupta and company having distribution point at Joynagar, since the said agency is nearer to their business place. That's one of the consideration. Whether my agency and the previous agency located same place or Singh's allocation point is same place, it is different. The dealers point are nearer to my agency. Who will get this? So direction may be given the director to take a decision on the issue, taking note of the observation given by the sub-divisional controller to the district controller, which has been forwarded to the director. Because consideration is the convenience and inconvenience of the dealer.
So the relinking is temporary.
Yes, temporarily. Should be.
Purely temporarily.
See, it may go 10 years also, your lordship knows.
With
because there are no application for compulsory appointment. There is no application to allow us to continue for some period. That has been recorded. I have shown to your lordship. So your lordship knows so far the appointment in vacancies
and
declared.
SP Singh brothers is also temporary.
Yes, yes, because we all are running our dealer agency with number of dealers. But due to death of Khan, this has temporarily initially been tagged with me. Now it has been taken back and given to Singh. Subdivisional controller says that all those dealers requested him, because he is the licensing authority, please retag the same with my client. I made a representation that is pending. I am praying before your lordship, consider the same, taking note of the subdivisional controller's report. Because
no, how are you aggrieved?
These all tagged dealers, which has initially been given to me,
yes,
that has been delinked and given to me, Mr. Singh. My volume of business has been reduced.
Volume of business in case of death of such,
yes. Because Khan is enjoying now. Not Khan, my lord. Singh is now enjoying. After this temporary tagging, his dealer's number is more than 50 than me. My learned friend is saying that there are some huge number of dealers with me. After this temporary tagging, he becomes, my lord, more than 50 dealers with him.
Lordship may kindly not overlook this part also, where the report says that temporary permission towards continuance of their business, nor fresh agreement upon reconstitution has been received from the
There's no scope for any re-agreement.
IOCL has not received any.
Yes.
That agreement is still with me. I cannot claim permanently these dealers. Also, Mr. Singh cannot.
And also,
because I don't have any copy of the report, I have not been given. But it is the report of the subdivisional controller on 11th of December. Kindly see the date.
And he
has taken note of the convenience of the dealers. So director maybe take a decision who will get it. Because not huge transport rebate is involved with the matter.
And this report on page 8
is
is
a
from
public
the same
exchequer.
person, Lordship, dated 28/1/25, which is after the letter that he is showing.
So this is the review order maybe.
That consideration. And after that, he has
He has
given
not
this
taken
report.
note of in the report, as I understood from my learned friend's reading, that this document of 11th December has not been taken note of.
No, whether you have made Messrs. SPC
No, I have
and
not,
brothers
because
a party.
he may be given an opportunity of hearing also. Because I have been given, that has been taken back. That's my challenge. What is the reason I have not been intimated? One fine morning, I saw, found that entire dealers temporarily tagged with me, taken back and given to somebody else. That's my grievance. And the sub-divisional controller says, necessary linking with me will suffice the convenience of the dealers, who are the prime consideration. In the report, there is no whisper about the dealers' grievance, as I understood.
And you are pleading that 74 dealers.
Yes, that's the issue of the sub-divisional control also. Now he is running with business with more than 50 dealers after this temporary tagging. It may be 50-50 also. Whatever the director will think it fit.
Whether the 74 dealers had made any representation like that?
My lord. Yeah, that's kindly come to page 35. Page 35. Last but one paragraph. Now the 74 dealers of Kultuli block want to tag them with Messrs. Goyal Gupta and company having distribution point at Joynagar, since the said agency is nearer to the, this is the sub-divisional controller, who is the licensing authority. He is the licensing authority of the dealers. He wrote it. None can raise disputes so far this communication is concerned. This is not the case of the state also.
No, that is not.
That has not been denied, cannot be denied.
Now, why will the
So
state?
convenience and inconvenience of the dealers are the prime consideration that has been ventilated in the communication of the sub-divisional controller, who is the licensing authority, ground level officer.
The state just points out that the same authority, the same personnel has definitely gone through all the representation, it can be presumed that has communicated with the directorate and thereafter sent this report.
That application,
is all.
my representation is pending. My learned friend is correct. My representation is when the first one has been taken note of. That is at page.
Page 31 is your representation.
And 33 is the reminder. You will kindly take note of 31. 18th October. I have stated everything, and that has been taken note of the sub-divisional controller at page 35.
Okay, heard. Please take down. Petitioner number 1 is a partnership firm. Who was appointed as kerosene oil agent at Mathurapur block 1 in Diamond Harbour subdivision, as well as in Joynagar 1 and 2, Roman 1 and Roman 2, and Kultoli block under Barukui subdivision. Full stop. After demise of upon death of one Abul Hasel Khan, proprietor of Messrs. Abul Hassan Khan, one of an agent. The allotted quota of the said agency was tagged temporarily with the petitioner. Accordingly, in May and June 2024, allotment of 108 capital KL and 144 capital KL on account of A.H. Khan was added in August 24 in the allotment of the present petitioner. It is the case of the petitioner that the quota of allotment for the month of December 2024, it appears that the quota on the account of A.H. Khan was given to one S.P. Singh and brothers instead of the present petitioner. He made a representation with the concerned Director of Consumer Goods as well as the Subdivisional Controller. None of the representations were answered by the authority. However, one document was placed by the petitioner, that is one of the letter dated 11th of December 2024, issued by the Subdivisional Controller to the District Controller, containing inter alia that 74 dealers of Kultoli block wanted to tag them with the petitioner company having distribution point at Joynagar, since the said agency is nearer to their business place. Mr. Sahara, learned counsel appearing on behalf of the petitioner, submit that by sudden direction of the authority, the business of the petitioner has been crunched. So we prayed for necessary direction so that the district director of consumer good direction upon the director of consumer goods so that his representation may be considered and he may be granted the quota of deceased agent Messrs. Abu Hassan Khan. Full stop. Learned counsel appearing on behalf of the authority concerned has submitted a brief case history wherefrom it appears that within bracket korun, as per order of Director of Consumer Goods, it is found that both the SKO capital agent of Messrs. KL Gupta and Company and Messrs. SP Singh and Brothers have storage point which are equidistant from Messrs. Abul Hassan Khan, Jayanagar. But the RC position of Messrs. K.L. Gupta and Company is significantly higher than Messrs. S.P. Singh and Brothers. Full stop. Therefore, as per the order, comma, all the dealers tagged with Messrs. K.L. Gupta under account of Messrs. Abu Hossein Khan have been delinked and relinked temporarily with nearby SKO agent Messrs. SP Singh and Brothers for smooth running of PDS. After perusing the brief case history of the respondent, it appears that the respondent authority has assigned reason for retagging the dealers of Messrs. Abu Hassan Khan with the dealer with the agent of Messrs. SP Singh and Brothers. I find no justification to the fact why initially those dealers were not tagged with Mr. SP Singh and Brothers just after the demise of Messrs. Abdul Halim Khan. Full stop. Furthermore, the pair of agents, pair of number of agents attached with Messrs. Abul Hassan Khan place their representation with the concerned SCFS. Considering the same,
But dealers have made the representation, not the agent.
বললাম তো numbers of dealers কি বললাম তাই বলেছি না কি বললাম number of dealers have made the representation with হ্যাঁ তারপরে কি বলেছি Abul Hassan Khan. Abul Hassan Khan. Furthermore, numbers of dealers, agent account, number of dealers attached with Messrs. Abul Hassan Khan. কি বলেছি তারপরে had made their FS SCFS subdivision contract. Considering the same, it appears to me that the prayer of the petitioner has some justification to be determined by the Director of Consumer Goods according to the provisions of law. I further observe that the prime necessity for distribution of kerosene oil through the dealer is the sole consideration of this matter. So, Director of Consumer Goods shall consider the matter at the time of disposing of the representation. Under the above observation,
Disposing of the representation.
at the time of disposing of the representation, under the above observation, each representation is disposed of with a direction to the Director of Consumer Good concern, being respondent number 2, respondent number 2 of this writ petition to dispose of the representation of the petitioner being annexure P4 within bracket page 31 of the writ petition, with taking note of the report of the SCF is concerned, being annexed P5 of the writ petition, within bracket, page 35, and shall pass a written decision according to the provisions of law. The respondent number 2 shall dispose of the representation within 6 weeks from the date of passing of this order, from the date of communication of this order by the petitioner, by giving sufficient opportunity of being heard to the petitioner as well as to the representatives of Messrs. Okay, Messrs. S.P. Singh and Brothers. Mr. S.P. Singh and Brothers. Both the petitioner and Mr. S.P. Singh and Brothers, Mr. S.P. Singh and Brothers is at leave to place their respective documents before the district, before the respondent number 2. Full stop. The decision of the respondent number 2 shall be intimated to the parties within 2 weeks thereafter. Full stop. This court has not entered into the merit of this matter. The respondent number 2 shall dispose of the representation without being influenced by any observation passed by this court. Since no affidavits have been exchanged, the allegation made in the writ petition shall be deemed to have been not admitted. Affidavit of service filed on behalf of the petitioner is taken on take. This full stop. Great production. Next.
Cannot be finished. Tomorrow, just not today. Not today.
26.
I am for the petition.
Very well. Not today, next.
I appear on behalf of the state.
Supplementary high school visit.
Yes.
After the first day of hearing, my lord, a supplementary affidavit has been filed with the behalf of the lordship. In supplementary affidavit,
What is the matter about?
My lord,
what is the matter about?
matter about, my lord, the selection of the EPS.
Especially a vacancy matter.
Matter about election and issuance of license to the respondent number 6.
You are appearing on the respondent of 6.
License that been allocated.
Okay, your granting of license in favor of respondent number 6 has been challenged here.
Yes, yes,
Yes. What is the ground?
Well, first ground I took, my lord, on the date of advertisement, what was the law? What is the instruction of the government? That should be followed. According to me, my lord, in my humble submission, they have stated in annexure, which under challenge annexure P3 page 28.
P3 page 28 of the writ petition.
My lord, writ petition. They also kindly 6 lines. As such, the district level fair price shop selection committee of the Purva Bardhaman district have decided to arrange a face-to-face interview in terms of clause 20 III, order number 2013 and subsequent amendment of PS dealer. But according to Hamd submission, that was not the on the date of advertisement. That was not the rule.
Your Lordship, the All the applicants, your lordship will see page 28, there were 4 applicants.
Just wait, let him finish.
The
Why you are
advertisement was
starting?
made on 11th of December 2023.
Now,
11th of December 2023, advertisement was made for filling of the vacancy.
date of advantage.
Date of advertisement.
When?
11th of December 2023.
11th of December 2023. Yes.
And date of interview was fixed on 19th of November 2024. Just about 1 year. Well, that was the initial challenge before Lordship. That was my initial challenge.
No, P3. P3 is your initial challenge.
Malad. Initial challenge.
That is the interview letter.
Interview selection process. Selection procedure. Which is
What is your name?
That is under challenge selection procedure.
What is your name? Kaveri Banerjee.
Kaveri Banerjee.
Whether you appeared there?
Yes, yes, ma'am. I appeared.
Then why you challenge this?
Malad, challenge
Why you
because
appeared there?
because malad, that selection procedure, according to humble submission, my lord.
That is very much fair play.
Malad, if that was not
Forget
provided,
about the rule.
if
All
that
the persons were given same opportunity.
but the Supreme Court says otherwise.
Yes.
Apex Court decided the issue in other way.
Very well. No, how you suffer?
Well, because it was not decided. Face-to-face interview, what does it mean? Why? What was it necessary? Face-to-face interview, why did you choose to select that procedure only?
No, only not that procedure.
Man,
This
that
is
was
the-
except that is appearing from the document itself. Face-to-face interview.
No, you must have not appeared there and rejected and objected that.
No, I am not on that. But I am challenging specific selection procedure.
No, you first you have accepted that. You have participated in the process. Thereafter, whether you can challenge.
Malad, if the selection procedure is bad,
then you have to challenge it.
Malad,
You have not to participate.
Malad, because of that, my lord, I have challenged on that ground, first ground, my lord, and I am supported by Supreme Court judgment, my lord. The Supreme Court
No,
said
you have to show that the conduct of the authority is arbitrary, unreasonable, and partially to favoring any person.
Malad, I am not on that. I am insisting. I am making my submissions specifically on the ground. The law of what was on the date of interview, that ought to have been followed. Beyond that, you cannot go. And the Supreme Court, number of decisions Supreme Court says, the rule, the date of interview, what the law was, that is to be followed.
Okay.
My lord, that is one point, my lord. That is first point. And second point, my lord, subsequently, my lord, I came to learn that I have filed supplementary affidavit, my lord. The dealership, whether the vacancy can be at all advertised, my lord, that was a stay order granted by the Honorable Court division bench. The issue was whether the National Food Safety Act 2013 was made applicable or the vacancy is 7.
The division
Kindly come to the order of this Honorable Court. It starts from page 6. Page 7 if your lordship can remember. There are batch of appeals. Mr. Saharai, for the appearance contains the state has taken pre-verificating stands with regard to you.
I know that order. I know that order very much. I know that order. I am aware about that order.
Yes, my lord. That because of that stand taken by the different stand taken by the government before the appeal court, my lord. There is
an order of interim order. There is an interim
order still continuing. Therefore, my lord, if I am covered by the interim order,
no, interim order is respect to the parties to the list.
This is the issue is this.
No, whether if the control order, which was challenged before a batch of appeal before the division bench, goes in favor of the petitioners, the petitioner will be benefited.
The petitioner,
And entire law, if the division bench pleased to declare the entire control order to be ultra vires, the necessary implication will follow.
that be the show, my lord. The interim order subsisting as on date.
No, interim order substituting adjourned date in respect of the parties to the lease.
That is not said.
Other parties.
But that is
That
not
has
said
been
so.
clarified
No,
subsequently.
it is
That is
very
not
much
said
clear.
so.
That
My
is
lord,
very
that is
much
not
clear
said so. When the issue in question, the issue is pending, my lord, your lordship kindly come.
Your lordship.
Annex the entire order, my lord. That is not said. That is not clear. That is not said so.
Whatever may be, lease is there in a batch of appeals. Different petitioners are there. Different dealers are there. Different distributors are there. They have challenged a batch of appeals before the division.
Your lordship, may I?
Division bench has specifically clear.
Notification itself is under challenge. Notification
I
cannot be
understand.
made.
If the notification goes, everything will be go. Everything will be go. That is the end result. If the order succeeds,
as on date,
all the matter would be washed
as,
away.
as on date, when I have brought you a lordship notice regarding the stay which is still subsisting, your lordship can take judicial notice of that, my lord, because the issue in question is also pending with the division bench. Some issue. Whether your lordship can, my lord, ignore or cannot go beyond that. Interim order has some force for your lordship consideration.
No, interim order says no dealers. You just read the interim.
Shall we detect?
No dealers. That means dealers in the lease. No distributors in the lease.
And the same has been clarified
And
by
it
the
was
division
not
bench
passed like that. The control order.
Notification itself is under challenge.
Notification challenge. I know.
Yes.
I know the fact. Notification under challenge.
If
So by the order, you cannot stall the entire process.
When the notification cannot be made at all. It is the stand taken by the division bench.
No, look, that is not the way. Way is that one law is now running. It was not passed to be a ultra vires. Okay. It was running. It was not declared to be ultra vires. So the state has to proceed according to the law.
Issue in question is pending before this division bench.
May be pending.
Identical issue.
No, your
Identical issue may be there.
Wrong submission,
but
your lordship.
but
May
the
I?
interim order is otherwise, not staying the entire process of the control order. Is there any order? Entire process of the control order should be stopped.
Interim order, if you say interim order,
Interim order.
Kindly see, interim order.
Operation of the control order was not stalled. Only dealer and distributor in the lease are binding by the interim order.
And restricted only to the
That's
DTAG
why
issue.
all the parties filed the writ applications. More than 100 writ applications have stayed following that direction of the division bench. Because of that fact, they have to come to this court.
Direct none of the ration card holders shall be dealing from the dealers.
Yes.
The dealers shall not be dealing from the distributors if not already done.
Not the control order.
Exactly.
No, on the basis of the control order, the interim order, that order itself is under challenge. Because
I understand, sir. I understand, but the interim order is not like that to stay the all further proceeding of the control order.
I submit before lordship, my lord, because National Food Safety Act as well as the West Bengal control order. This is practically.
I understand the situation. I understand. I know the law and the direction passed by the single bench. Thereafter the division bench.
The division bench, when the matter is seasoned before the division bench, my lord, your lordship can adjourn the matter for some days, my lord, so that I can take.
Your lordship, the matter can be disposed of right here, right now. This is a resultant vacancy, your lordship. This has nothing to do with delinking of the existing vacancy.
No.
And the order, division bench order does not apply, your lordship.
Vacancy
Your
itself
lordship,
cannot be done.
Your Lordship, this is
They have already appointed.
already appointment has
cannot be
been given,
done.
Your
That
Lordship.
is the stand
Your
taken
Lordship,
on
that is not the
bench.
order of the division bench.
Participated in the selection.
Your Lordship participated without any objection, and now, Your Lordship, a number of Your Lordship, number of Supreme Court judgments we can produce that after participating without any objection, after not being rejected, now she comes up and says the interview could not have been taken. That cannot be done, Your Lordship. Umpteen number of judgments are there of the Supreme Court. This is the law of the land. Your Lordship, and the
You
division
have to
bench.
come before issuing the license.
And Your Lordship, in the
the
writ
license
petition
has
also.
come.
If I am bringing into Lordship's notice, when the vacancy itself cannot be published, how could they do it?
Your Lordship, this is not the case made out in the writ petition at all.
But that is the Supreme Court division bench judgment is so.
Division bench judgment is
Well,
not
kindly
that,
see-
Your Lordship.
I have read the division bench judgment. You read it.
My learned
It is
senior
about the
friend is
dealers.
perhaps misconstruing the division bench order, Your Lordship. And this
It
is
is
not the
about the
case made
dealers
out in the writ
and
petition as well.
distributors. Specific dealers and distributors.
Specific delinking এর জন্য.
My Lord, your Lordship had pleaded that the act has been fully implemented. However, in the written submissions placed before the honorable single bench, the stance was that the act has not been fully implemented. Honorable single bench ought not to have relied on such submissions and runs counter to the stance taken by the state in special petition pending with the honorable apex court.
The operative part.
Until unless the operation of the control order was stalled, they can proceed.
Proceed, yes, Your Lord. And this is the resultant vacancy, Your Lordship.
When the issuing question before ending with the division
No,
bench
Your
of the
Lordship.
Supreme Court, your Lordship can adjourn matter for some time.
No, Your Lordship.
With instructions before Lordship.
I have thousands of matters on that matter.
Because your Lordship is in.
Yes, I have the
That is
determination.
and that is restricted only to
Regularly
delinking.
control order is running.
Yes,
Control order is not ordered to be ultra vires. So the state has to act upon the control virus. Otherwise, distribution of public system would be stalled.
Controversy with regard to the implementation of.
I understand, sir.
Safety Act, Food Safety Act, or
Your
the
Lordship,
control order.
Control order
These are
was
the controversy
challenged
ones.
only to
These
the
are the-
extent of delinking and linking. This is not even the issue made out in the writ petition. Your Lordship, the writ petition Your Lordship will kindly see this is not even the case made out in the writ petition.
Yes.
The writ petition was only restricted to why interview has been held.
Being an unsuccessful candidate, challenge the same without any protest
And the
before the authority.
license has already been granted and the allotment been made, Your Lordship.
Distribution also.
Your Lordship, she ought not have participated in the interview if she was aggrieved by the same. After participating and after being rejected,
My submission is your Lordship can adjourn the matter for 2 or 3 days. I come back.
Your Lordship, kindly
Your Lordship, this matter.
What you want to demonstrate?
I shall be able to satisfy your Lordship with my
Your
subsequent.
Lordship, kindly fixes it.
Fixing it for order.
For orders, Your Lordship. Sometimes in the mid of April, Your Lordship. Next week, Your Lordship will be some difficulty.
No, this time also, Lordship, kindly keep it. I am praying for 2 days time. 2 days.
2 days এই সপ্তাহে নিতে পারবে না যাচ্ছে।
Today, I don't have the determination.
Your Lordship, next week I am in some difficulty, Your Lordship. Your Lordship will
Very. Having heard the learned counsel for the parties, the matter, I have heard the matter at length. Let the matter fixed on 12th of March 2025.
Grateful, Your Lordship.
Under the heading of order for orders. Under the heading for orders. Orders.
Okay. Gratefully.
Agent.